Monday and Tuesday, continuing, as I indicated, Public Protector and Advocate Mpofu and the team will be joining us virtual. We will then take a 5-day pause, that from the Wednesday of next week would pause on the hearings until the Wednesday of that week, to allow their own work that they need to do. The committee secretary might come to you, because I do have an intention that we might want to use one day next week just for our committee meeting with the legal services about certain key critical judgment that we would want to spend half a day on our own on those issues, especially with the fact that you would have finished a week.
The chair, am I the only one?
You would have.
You're not saying, you can hear him. Access him.
We can hear you. Can you hear me now?
Me neither, committee member.
Okay, can you just fix that? I will pause a bit. Let's just fix that, IT.
I only have a visual of it. I cannot hear your voice at all.
Okay, no, we are fixing that. I was not aware. Our apologies. Can you hear us now, Mr. Johann van Loggerenberg?
Yes, good morning, Chairperson. I think some of the other members also raised the inability to hear the proceedings.
That's fine. Honorable Malema, can you hear us?
I can hear you, Chair. Good morning, Chair, members of the committee.
Thank you very much. Thank you for alerting us on that. My sincere apologies to members. I will briefly restart what I was saying so that you're not left out. I was indicating, colleagues, that we're starting in a few minutes to resume with Advocate Mpofu to cross-examine the witness. That it is my hope and intention that perhaps by lunchtime we would have concluded with the witness, and that after lunch you could introduce the next witness. I will have to manage that as we go through that. I also indicated that the directives have been issued yesterday, and that members and evidence leaders and the team of the Public Protector must not be surprised when I start invoking them as they are. Thirdly, I went on therefore to indicate that Advocate Dali Mpofu and the Public Protector had indicated to us quite early that Monday and Tuesday they will be virtual, and that from Wednesday next week up until Tuesday that week, for 5 days they would not be available. We have accepted that, and for that it therefore means that we're going to have a pause of 5 days from Wednesday next week until that Wednesday. And I was therefore, when you intervened, Honorable Malema, I was on the point saying one of the days next week we are going to utilize as a committee to just talk about a few things in relation to our work in the hearing, and so leave space. That is therefore my request in all of your busy scheduled for a day next week where we'll have that committee meeting to attend and assist ourselves on a few matters that are going to be important. Thank you. That would have been the longest remark of resuming the meeting. I now am going to recognize Advocate Mpofu to continue with his cross-examination. Thank you.
Thank you very much, Chair.
Just pause. Mr. Johann van Loggerenberg?
Yes, Chairperson, I'm uncertain of the procedures. There were a number of questions put to me yesterday which were left up in the air. I went and reviewed the recordings of my testimony on both day 1 and 2, and would like to bring them back from up in the air if that is permissible. But I don't know, I'll leave it to you and the committee to determine. Thank you, Chair.
Okay, that's fair enough. Advocate Mpofu?
Chair, I'm neutral on the threat,
Sure, no,
except
thank
for
you.
this to say that some of those matters might, an opportunity to bring them from the air, as he puts it, might come now. So he might want to do that after I've finished with him.
Okay. That's also fair, Mr. Johann, so that you can come back to those later on.
Thank you. That would be fine. If that's the case. Thank you, Chairperson. Thank you, Mr. Mpofu.
I will remember that. Thank you. Advocate Mpofu?
Thank you very much, Chair. Good morning, Mr. van Loggerenberg.
Good morning, sir.
Yes. Okay. Look, yeah, it's a pity that we don't have a lot of time, because I wanted to just shape this, the rest of this cross-examination in such a way that it's actually going to help us going forward, because the structure that we are following hopefully will assist us with other witnesses. I know you are the guinea pig because you are the first witness. But we'll see how that goes. Can I start by just saying the following for your benefit and for the benefit of the members, Chairperson? Yes. Mr. van Loggerenberg, I've reduced the issues that I'm going to be raising with you into 5 topics, Chairperson, and I think that will also be for the benefit of the members. I call them the big 5, being a South African.
Okay.
Okay. All right. So the first issue, and I think we covered this sufficiently yesterday, is the issue about your being, quote unquote, ignored and not being traced and so on. You remember that whole issue?
Yes, Chairperson.
Yes. And I think you and I have agreed, subject to some qualifications, that if we are able to show through evidence of the public protector or even other witnesses that she, A, was told by investigators on whom she had confidence that they couldn't find you, even if those people can be criticized, but at least she would have had reason to accept their evidence at face value. I know, and I say subject to certain qualifications, that's just to save time. So I'm not suggesting that you accept that in an unqualified manner. Do you understand?
Yes, Chairperson.
Thank you. Then, so that's the first issue. And as I say, we can tick because we dealt with it yesterday. Yeah. The second issue, there's just one thing, one question literally that I'll ask you to bring that one from the air, hopefully. Okay. Then the second issue is about the so-called rogue unit. And there are 2 issues. One is the existence of the unit, which I think is common cause, at least up to 2014. It's common cause. Whether it continued thereafter and so on as the PP believed, or it stopped, that's another issue of dispute. But at least as far as its existence is concerned, we are one, me and you, correct?
I hear you, Chairperson.
Thank you. Right. Now, So that issue is also almost covered. And let me just pause and say this, Chair, and again, this is for the benefit of the members. It is true that it's not the business of this committee to determine whether there's a rogue unit or no rogue unit and so on. That's for Skakane and KPMG and all those people. Of course, if we go as far as to establish that, then it might be a shortcut, but that's not your main focus. Your main focus is whether the belief by the public protector that is indeed so was outrageous and impeachable. That's really the only issue for you. Yeah. So the third issue then, Mr. van Loggerenberg, which really goes to the nub, and I know there's some debates about it, but I'm sure it will be clear in due course to those to whom it's not clear, is that the court findings to the effect that the public protector's views on all these matters were outrageous, or all sorts of adjectives that are used, mischievous, fallacious, what have you, that those conclusions on the facts that will be placed before this tribunal are unjustified. Okay, that's probably the biggest job for us. It's not for you, yeah. But we will lead some of that evidence via you to the extent that it is relevant to you. Do you understand that?
I hear you, Chairperson.
Thank you. But do you understand? Yes, I know you're here.
Yes, you are explaining the big five.
The big, yes. Okay.
Up to
Right.
3.
That's fine. Now, the fourth issue is that, and that's a broad issue related to the third one, is that the gist of the court findings is that, let's go. I'm avoiding to use the term fait accompli, but what I mean is that there was really no investigation. She was just going through the motions with a predetermined outcome, and that is also a theme that comes from both your evidence and some of the judgments. Understand that? Yeah. All right. And then out of those, I'm going to pick out one so that I don't have to go through all of those, like Kakane, KPMG, what have you. We've dealt with most of that. So I'm going to demonstrate this fact by you and I discussing the IGI report in relation to your views on it, but also in relation to the comments made by the court. And just to show again that her conduct regarding the IGI report was actually justified and commendable, firstly, but secondly, that she's not a Sangoma. In other words, she wouldn't have known, for example, that your review would be granted a year later. But I don't think you and I will quibble about that. Understand that one?
I hear you, Chairperson.
Okay, thank you.
Now you have all 5 of the big 5.
Thank you. Yes, that's the big 5. So I'm going to then go, as I say, the first one is done. The only thing about the first one is I want to ask you to confirm that you, at some stage, deliberately used the wrong surname that is misspelled, not necessarily that you called yourself Van der Merwe or something, but you used the surname that, and I'm saying that in the context that it might have contributed to your untraceability, not to cast aspersions on you. You used a surname that was the wrong one, misspelled. Correct?
If on my email, yes, Chairperson.
Yes.
My official email. I didn't deliberately do it, but it was just, in fact, if you look at the correspondence between Parliament and my attorney, my surname is spelled incorrectly again. It's a difficult surname. It's actually Van Loggerenberg.
Loggerenberg.
Van Loggerenberg. Yeah, okay.
Yes,
Yes, but
doesn't matter. It's been used in multiple formats over my lifetime.
Okay.
yes, okay. And again, I'm saying, when I say deliberately, don't take me wrong.
Just pause, Advocate.
So sorry,
Mpofu.
Chair.
Sorry, Mr. Wolf, can I just check? Are you putting to Mr. van Loggerenberg that it's because his surname was wrongly spelled that he wasn't able to be found? Is that the version being put?
No, no,
Okay.
no. Yes. Thank you.
Okay.
Yeah.
Okay. Proceed then.
Thank you. I'm saying, Mr. van Loggerenberg, again, I'm not fighting with you. I'm saying, when I say deliberately, I'm saying that you were aware that this was happening and you, let's call it, condoned it. Not that, I'm not saying you are the one who went there and doctored the
Yes. No, I never had an issue with it because I understood. Many people have difficulty with the surname, as do I. I didn't select it. All the people who ever spoke with me knew it was me. That was fine. It's not an issue.
Yeah, but I'm just saying, if someone didn't speak to you, if I, for example, wanted to find you, and if I Google the wrong surname because I've got the wrong surname, then obviously I'm not going to find you. Obvious. Let's say in some database, correct?
Yeah, no, sure.
Thank you. Right. Okay. So that's the end of the number one, Chair. That's all I need for you as far as the one of the big five. Yeah. All right. Then on the second one, excuse me, again, I don't want to get into a debate with you as to whether the so-called rogue unit still exists and so on. We'll canvass that with other witnesses. In any event, even if it still existed, you left SARS at 2015. That's common cause.
Yes, Chair.
Thank you. So, okay, Chair, that then covers that because, as I said, on that one, it's existence and continuation. Existence is common cause, but at least, again, I don't want to misrepresent the evidence. Existence is common cause up until 2014. Continued existence, we've just covered. Okay, good. Then,
Sorry, Chairperson, if I may add to my answer, please.
Yes. Go ahead.
sorry.
It has always been part of the propaganda that the existence of the investigative unit that had the three names that I identified in my evidence in chief was somehow denied or kept undercover or whatever the case might be throughout the years of its existence. I just want to emphatically say that that was never the case, and the evidence put before the court in my 4 affidavits quite clearly demonstrate that. Thank you, Chairperson.
Thank you, Chair. And for the avoidance of any doubt, I want to put it on record that I agree with you on that proposition. The existence of the unit, people quibble, I call it the so-called rogue unit, you call it the high-risk unit or whatever. That's let's put that aside. But the fact that there was such a unit has not been denied, and actually is undeniable. There are two issues, two aspects, which I want to canvass with you. Oh, well, which I would have wanted to canvass with you, but I can only canvass one of them. The one is this issue of the continued existence, but it would be unfair because let's assume somebody restarted it in 2016 when you were gone. I can't ask you about that. So I think we've both accepted that. But the second issue, which is really where the bone of contention, for lack of a better word, is the rogueness, if you know what I mean, of the unit. That's obviously hotly contested. You would agree?
Yeah, it was hotly contested between you and I.
Yeah.
Mr.
No. Okay. No, I thought you were just talking general. I'm saying it might be hotly contested between you and I, but I'm saying generally that's the issue that has been playing itself out there, outside of you and I. I agree, you and I have contested it. But I'm just saying that's the issue. Whether it's rogue, quote unquote, meaning it is unlawful or in breach of the Constitution and that kind of thing. You agree that that's the contested terrain?
Yes, Chairperson, the first time that that unit was referred to in that manner was on 12 October 2014 in the Sunday Times on a front page article with the headline, SARS but Zuma. The article claimed that this unit and members of the unit had broken into the private home of former President Jacob Zuma and planted listening devices in his home and secretly and unlawfully listened in on conversations that transpired in that premise. It also made claims of the unit having been involved in tarnishing the reputations of certain former South African Revenue Service officials. Following that, there's a string, I think about 54 claims, such as that the unit acquired new homes, it had slush funds in excess of 600, and in other cases 800 million rands. It purchased new vehicles, it purchased all sorts of sophisticated spyware, in particular grabber, and so forth. It also infiltrated politicians as bodyguards. It conducted house penetrations, and so forth.
Yeah.
There are a long list, 54 of them, in fact. And it is then in that context that every time that article, those articles appeared over 2 calendar years, that instead of referring to that unit as its convention within the Revenue Service, it was referred to in that manner.
Yeah, thank you. Again, I agree with you. All I wanted to establish for the purposes of this committee again, because we have to focus it to the work that we're doing here, is that you would agree with me. I'm putting a proposition to you so that you agree or disagree. That apart from you and I, out there are South Africans, I don't know how many, who will agree with you that the unit was above board, nothing wrong with it, and so on and so on. There's another large number of South Africans, again, I don't know how many, who believe that the unit was unlawful and rogue and all the things you've just enumerated. And I'm asking that question to demonstrate that it's not the function of this committee to resolve that public debate. The function of this committee is simply to find out whether the findings of the public protector in that regard were wayward and outlandish and ridiculous or whatever. Yes, thank you.
No, so that is unfortunately how a successful propaganda campaign works.
Yes.
The label will remain for long beyond our lifetime.
100%. And we just want to know that to the extent that the propaganda must have worked on the public protector, whether that's outlandish or not. Okay? All right. Now, That's fine. So, I'm sorry. You and I, on that topic, then I'm just going to ask you a few questions. You accept that, among other things, the public protector, rightly or wrongly, and I'll come back to the rightly or wrongly, I'm just packing it. In coming to her conclusions about the rogueness, quote unquote, or let me use a more neutral term, the unlawfulness and unconstitutionality of the unit had, among other things, the following information at her disposal. The Kpmg Report, which found that the unit was unlawful. Okay? Do you agree with that? I'm not saying you agree with this Kpmg Report. I'm saying, do you agree that that's one of the materials that she had at her disposal?
Indeed. The way I understand it is that the Public Protector accepted the Kpmg Report as is.
Yes, good. And the second material on which she relied for that belief was the Kpmg Report, correct?
Correct, Chairperson, but she did not take into account the withdrawal.
Yes, okay. We'll come to that, Mr. In fact, we won't, because we won't come to that.
To put it differently, she relied on the original Kpmg Report.
Yes, in respect of which and you'll correct me because you are more familiar with this. You issued a media statement vigorously contesting the extent of that withdrawal. In other words, you were saying Kpmg did not withdraw some of the evidence, the body of the evidence, but they only withdrew the conclusions, and you were aggrieved by that, correct?
Yes, I was aggrieved that they only withdrew the conclusions, recommendations, and legal opinions.
Thank you very much. So even you understood that that withdrawal was not complete, hence you were aggrieved.
Correct.
Thank you. Now, the only other thing then I want to say about Kpmg is that you part of the material that, or part of your qualms with the extent of their retraction was the fact that it left some parts of it untouched, and just accept that for now as a general statement, because that's not the nub of my question. The nub of my question is that in those parts that were not withdrawn, and I'm using that term loosely, was, among other things, the list of what they regarded as interception equipment, intelligence type of equipment, quote unquote, which would be evidence of the rogueness. I'm paraphrasing, but that's, among other things, that was part of your gripe, correct?
No, because they did not ascribe the equipment to the unit in question.
What did they ascribe it to?
They just used the term SARS.
Yes, I hear you. Okay, no, fair enough. And again, so that was part of the gripe, that they listed all this quote-unquote rogue equipment and simply ascribed it to SARS without allocating it to a particular unit. That was one of your gripes, correct?
Yes, it was, certainly.
Thank you. Okay, no, that's good enough for our purposes. Right. Then, Okay, so that was the second thing. So that's Kakane, KPMG. And then the third thing that was at the disposal of the Public Protector was the Kroon report, correct? Kroon panel.
No, there was no Kroon report.
Okay, yeah, okay, let's call it Kroon panel, whatever
Press
you call
release.
it. Yeah, document,
The press release.
whatever, yes, press release.
That's the title at the top of the document.
Absolutely, I'm with you. Today we're agreeing on everything, yeah. I'll take yours. Kroon press release, number 3, correct?
Thank you, Chair.
Thank you. And then the fourth material that was relied on was the Inspector General of Intelligence report, correct?
No, Chairperson. Incorrect.
No, well, I don't understand.
Well, the report says that Ms. Mkhwebane did not have the report.
Which report? The
Inspector
PP?
General of Intelligence report.
No, sorry, that was a confusing question. So what you are saying is the PP's report says that the PP did not have the IGI report. The word report was
Correct.
ambiguous. That's what you are trying to
Correct,
say.
yes.
Okay. All right. But you accept that she must have relied on it because she, even in the PP's report, refers to its recommendations that you must be criminally charged.
I don't accept that because I don't want to place myself in the shoes of Ms. Mkhwebane. I think Ms. Mkhwebane can explain that herself.
Fair enough.
All I know is that the report emphatically states she did not have the report. She had certain aspects thereof on good authority. How she verified whether those aspects on good authority were indeed what was contained in the report or not, I cannot say. I have my views, given the fact that we now know that she was in fact in possession of the report, but the report states otherwise.
Okay. Now it looks, thank you. Looks then if, Chair, again, I'm doing this to try and speed things up. So I'm just going to sit on this just for a short while, Mr. van Loggerenberg, because I want to kill 2 birds with 1 stone, so to speak. Sorry, Chair. Yeah, the good authority. 113. Okay. Whoever is operating the IT system, can you go to paragraph 113? Of the judgment. The one we're talking about, 48521. The rogue unit judgment.
Okay, just a pause there so that
Thank you, Chair.
we get it flighted.
While we are at it, while they're finding the thing, I just want to confirm. So you're saying you're basing this theory on the fact that in the report, Advocate Mkhwebane, as you put it, emphatically stated that she did not have the report. Correct?
Yes, Chairperson.
Thank you. All right. Okay, well, again, to save time, Chair, I'll just ask the next question while they're looking for the thing.
Please go ahead.
Yes. And the issue I'm going to demonstrate when I say kill two birds with one stone is that you are so wrong with what you've just said, and so is the judgment. So that's what I mean by kill two birds with one stone. So wrong. Like, so wrong. So what you've just said is, Advocate Mkhwebane says in the report, emphatically, as you say, that she did not have the IGI report. Where in the report does she say that?
We'd have to find that for you, Chair, if you can allow me a few
All right,
minutes.
I'll assist you.
All right.
If you have the report in front of you, you'll find the IGI, sorry. Section, sorry, I thought I had marked it. All right, I'll find it for you now, Mr. van Loggerenberg.
Advocate Mpofu, can I assist what you're looking for?
Yes.
The report.
The part in the report, the section that deals with the IGI report.
Could be around paragraphs 5225 on page 4264.
Yes, yes, you're quite right. 5225. Actually, it starts at 5. Oh yes, I know it's confusing because it's under the heading Sikakane report, but I'll also explain why that is so. Let's deal with that very quickly. Do you accept that in the report, it is clear that the IGI report is a product of the Sikakane report? In other words, one of the findings or recommendations of Advocate Sikakane was that the matter must be referred to the Inspector General. Are you able?
No, I don't accept that.
You don't accept that? All right.
But
All right, no, I'll assist you, don't worry. Relax. So if you go to the report at, my learned friend is almost correct. It starts at 5216 under the heading Sikakane report. And it answers also one of the questions that Honorable Gondwe raised about who commissioned what. The first 5216 says the Sikakane report was commissioned by the former SARS Commissioner, Mr. Ivan Pillay, to conduct an investigation into allegations of impropriety against Mr. Johann van Loggerenberg, SARS Group Executive Projects, Evidence Management and Technical Support, Mr. van Loggerenberg. The report outlined, amongst other things, issues pertaining to the intelligence unit. So you see how that starts. You confirm that part. Or rather, you can't dispute that part, that it was commissioned by Mr. Pillay to look into your conduct.
yes, it was not the unit, my conduct in relation to allegations made by Ms. Belinda Walter. It was very specific.
Mr. van Loggerenberg, do you confirm that paragraph?
I confirm it up to where my surname ends with closed brackets.
All right, that's fine. You can confirm it to wherever you want. Yeah. All right. Now, here's the part that you seem to be contesting. Go to the paragraph that my learned friend was referring us to, 5.2.25. And it says, the report recommended, in other words, the Sikakane report recommended that the activities and functions of the SPU be investigated by the Inspector General of Intelligence. Are you contesting that plain fact?
No, I did recommend that.
Good, thank you. All right. And that's what I was trying to say. You seem to be contesting that. I was saying the IGI report is therefore the product of the Sikakane report because it was recommended thereby. Well,
No,
now,
Chair, that's, I'm contesting precisely that point.
no,
In order for you to understand the genesis of the Inspector General of Intelligence report, which is in terms of Section 7 of the Intelligence Oversight Act, it was commissioned by the then Minister of State Security in August 2014, in terms of Section 7B of that Act, with
Yes.
a very specific mandate, scope, and purpose.
okay, Mr. van Loggerenberg, I'll grant you that. I don't care whether it might have been a coincidence. All I'm saying
Not
to
a
you,
coincidence, Chair.
no, listen to me, please. You don't answer before I finish my question. I'm saying the fact that Advocate Sikakane recommended that this matter goes to the IGI, and the fact that they may also have been doing it, I don't care if it's a coincidence or not. All I was saying to you is to establish the facts. The fact which you and I have agreed on is that Advocate Sikakane recommended that the issue of the unit be referred to the IGI. Yes?
Yes.
Thank you. That's
Sorry.
all.
By the South African Revenue Service.
Whatever. Yeah.
You just pause
No,
there.
not
Just,
that person, it's important.
Okay.
The
By,
recommendation by Advocate Sikakane was that the South African Revenue Service should refer the matter to the Inspector General of Intelligence.
fine.
thank you. Just a pause.
sorry, Chairperson.
Advocate Bauer.
I'm hoping to shortchange this by just reading out what the recommendation was from the Sikakane Commission so that we don't go around in circles as to precisely what it was. If
What?
that would assist everybody.
Sorry, I didn't hear that.
I'm hoping to clear this up quickly by just reading out what the recommendation was from the Sikakane Commission.
Yes. No,
Can
I'm
I-
talking about the report. The PP's report.
No, but you're going around in circles, it seems.
No,
to-
no, I don't appreciate that. I'm not going around in any circles. I'm reading the report recommended that the activities and functions of the SPU be investigated to the Inspector General of Intelligence. What circle is that? It's here.
Well, that's in the PP report.
Yes,
Mr.
but that's what I'm
Mpofu.
dealing with.
But the debate you're having with Mr. van Loggerenberg is whether that recommendation was actually made by the Sikakane Commission or
No,
not.
I don't. I just said I don't care about that. I don't know why you're telling me that. I've just said I do not care whether it was a coincidence or whether it was there or not. I'm reading words here.
Okay.
And you're telling me that I'm going in circles.
Mr.
The report of the Public Protector says the report, and when it says the report, it means the Sikakane report. You understand that, Mr. van Loggerenberg?
Should I?
Yes, Chairperson.
Yes. So let's read it together in straight lines, not in circles. The Sikakane report recommended that the activities and functions of the SPU be investigated by the Inspector General of Intelligence. That is what is in the Public Protector's report, yes or no?
It is correct, Chairperson.
Thank you. Right. Now, then it then says, in a meeting held between the Inspector General of Intelligence, Dr. Sitluma Maru Dintwe, on 31 January 2019, let's pause there. That is the meeting, apparently, that was played here on Monday for a long time. Chit-chatting with Ms. Govender and this one and that one. You agree?
Okay, just to be sure, are we on 5 to 26?
25, sorry, Mr. van Loggerenberg.
Okay.
We're still on 25.
Okay, thank you, Chair.
Okay, good. Now, it says this. He confirmed, Mr. Dintwe, that's the Inspector General of South Africa, confirmed that the office of the IGI had indeed previously investigated allegations of an intelligence unit within SARS and confirmed the existence thereof. You see that?
Yes, Chair.
Yes. In other words, in the meeting that was played here, Dintwe, among other things, confirmed that there was an investigation and which confirmed the existence of the rogue unit, so-called. Okay?
If you simplify it to that, yes, Chairperson.
Thank you very much. Right. Now, then the 26 is the one that then gives it a bit of context. It says, apparently the then Inspector General, that would be the late Advocate Faith Khadebe, conducted an investigation on the intelligence unit within SARS and issued a report on 31 October 2014. You have no quibble with that?
No? Chairperson, it is correct.
Yes, it's in straight lines. Okay. And then, which I was reliably informed that it was in the custody of the former Minister of State Security, Ms. Dipuo Letsatsi Duba, from whom I tried to get a declassified copy of the report without success. You have no quibble with that as well?
Yes, that's what it says.
Yes. Do you know, as a matter of fact, just to clean this up, Chair, that so much did the Public Protector make those attempts to get the declassified report that at some stage she even laid criminal charges against the minister?
Yeah, I read about it in the newspaper. Yes.
Yes.
Chairperson.
In fact, it was what one might call a skirmish. I think the minister also laid criminal charges against the Public Protector in that process. Are you also aware of that?
Yes, Chairperson.
Thank you. Right.
Chairperson, just if I might ask to go back to 5.2.24.
20?
24.
24. Yes, yes, let's do that.
Sorry, no. It's the one where reference to Advocate Sikakane.
Yes.
That paragraph that you just read out first before.
No, that
you
was
took me
25. I
general.
didn't go to 24. That was 25, but we can go wherever you want.
Just the one where there's reference to.
That's
Mr.
25.
Sikakane recommending that the matter
Yes,
be
that's
referred to
5.
the
So,
inspection.
sorry, Mr. van Loggerenberg. It's 5.2.25. I'm just saying it loud for the person who's operating. 25. Right? Yes, we are back there, Mr. van Loggerenberg.
No, sorry, Chairperson. There's a paragraph that was read out before 5.2.25,
Oh, I see.
which refers to the Sikakane
That's
recommendation.
That's 16, probably. The only other one that I read was 5.2.16, the one that said the Sikakane report was
that's the
commissioned,
one.
by former SARS Commissioner, Mr. Ivan Pillay, and so on.
Yes. So, Chairperson, I did not agree with the contention that brought us to what being laid out before the committee now. That the Inspector General report was an outflow of the Sikakane report for the simple reason that the Sikakane report is dated 5 November 2014, which is not evident in this paragraph. Whereas if you go to paragraph 5.2.25,
26, you mean? It's dated.
26, sorry, you will see that, in fact, by that time, the Inspector General of Intelligence report had already been concluded.
Good. That's exactly, I don't know which part of this is not clear. I do not care whether in fact, it was a coincidence or whatever. I'm saying
Okay, then
that,
it's
yeah.
fine, Chairperson, because that is what I was asked.
All right.
Okay, thank you.
I've said it to you. I've said it to
Proceed,
Bauer.
Advocate Mpofu.
Anyway, all right. Let's move on. Okay.
Just sorry, Chip, I don't want to interrupt there, but I think this point is rather important. I hear what Advocate Mpofu is saying, and he's reading from the Public Protector's report, but then the Public Protector is wrong as well. For the simple fact that the dates indicate that the other report was completed before the other one, so the deduction that the one was built on the other is factually wrong, and the committee needs to understand that and take that into consideration.
Yeah, but the public protector is wrong with what? When did the public protector say what you're saying, Dr.
Didn't,
Mulder?
sorry, Chair.
Go ahead,
You are reading from the Public Protector's Report, 5.2.5 or 5.1.6. In that report, the claim is made that the report from the Intelligence General was based on the other report. It seems that the facts indicate differently, and I think that's important for the committee to take cognizance. So if you say you're not interested in that, I understand that. But I'm interested, and I think the committee is as well.
Okay. Well, I hope this committee is only interested in the facts, not some fiction. Because all I have said...
No,
No.
Advocate Mpofu, I would want you to tone down
All
on
right.
that.
Okay.
Please.
Actually, I don't appreciate being interrupted in my cross-examination, but let me take your advice, Chair. Dr. Honorable Mulder, I have never and I will never say that the public protector said that the one report was as an outcome of the other one, because she simply has never said that. That's what I'm saying. All she says is, and I'm reading this for the umpteenth time, the Sikakane report recommended that the activities and functions of the SPU be investigated by the Inspector General of Intelligence, full stop. That's all she said. I've never said what you are attributing to the public protector.
Okay.
Thanks. Thank you. Let's go.
Honorable Bonde, I'll come back.
All right.
Honorable
Now-
Bonde, just pause, Advocate Mpofu.
Sorry.
Yes, Honorable Chairperson, and good morning to everybody. I'm also a bit concerned with paragraph 5.2.25, I think.
Yes.
Adequate Bauer was about to just point out what, the actual recommendation in that report, the Sikakane report, actually was. And I think it's important, we just want to hear her if possible, because she didn't quite get a chance to indicate. Because what we had on the screen was the interpretation of the public protector around what the report recommended. And she was trying to put it on record, what actually was the recommendation in the report. So I would really appreciate it. I beg your indulgence on this, Chair.
So you're requesting that we have that read to us?
The
Sikakane
yes,
recommendation.
the recommendation, the point that she wanted to make, for her to make that point, because I think it's
Okay.
very important that we get, that also on record.
Just pause, Advocate Mpofu.
Yeah, I was going to say I have no problem.
I don't think that is a train smash. Can we do that?
I don't have it to put it on the screen because our operator doesn't have it, but we'll make it available. There's a series of recommendations in the report, but I think the one that relates to this is 190.4, which is on 217 of the record. It says, in respect of the unlawful establishment of the Special Products Unit /NRG/HRIU, the following is recommended. Sub 1. As we understand it, the Inspector General of Intelligence is already investigating Ms. Walter's complaint. The activities and functions of this unit must be specifically investigated by the Inspector General. Alternatively, we are of the view that the Commissioner should recommend to the President that Judicial Commission of Inquiry with powers of compulsion in terms of Section 3 of the Commissions Act 8 of 1947 should be appointed. Such commission, if considered, and then it goes on to what that commission should do, which is not relevant to the debate, and then it goes on in sub 3, which is SARS should ensure that proper structures of cooperation between SARS and government agencies statutorily tasked with intelligence gathering and crime investigation are established in order to assist SARS with capacity. I was trying to point out earlier that I think Mr. van Loggerenberg and Advocate Mpofu were talking across each other on different sections of the Sikakane report.
No. Thank you. Can I carry on now with my cross-examination?
Continue, yes.
Thank you. So, from what has been read, it looks like the situation is even better than what I was describing. What Ms. Bauer has now read to the committee is that Advocate Kakane was even aware that the IGI was conducting a report and made recommendations that whatever was read. Would you agree with that?
It appears to be the case, Chairperson.
Thank you very much. So thank you. So it's even better. All right. Thank you, Honorable Kondo. So, let's go back to where we were. I was saying,
Chairperson, that it appears that Mr. Sikakane was unaware at the time when he published his recommendation that the Inspector General of Intelligence had already concluded the investigation.
correct, because of what you pointed out, the November, October thing. That's correct, yeah, I agree with you there. All right, now, the point though, which is the business of us, of this committee, is that, okay, we've already said, we agree that he was reliably informed, she being the public protector was reliably informed that it was in the custody of the former minister, and then they were fighting it out. Now, 27, the next one. He says, in an attempt, the public protector says, in an attempt to determine the veracity of the allegations of the existence and activities of the intelligence unit, I sought more information from the Inspector General of Intelligence, that's Dr. Dinktwe. This information was attributed to a report by the former IGI, Advocate Khadebe, dated 2014. The OIGI report. You and I, we've gone through this now. You confirm that?
Yes, Chairperson.
Thank you. Then he stated that the report can be requested from the Minister of State Security as the lawful custodian thereof, right?
Yes, Chairperson.
Okay, then the rest I'm just going to paraphrase. It's the thing about the fight, the criminal charges and so on. We've already covered that. Now, if you go to, okay, no, let's pause here. This, what we've now discussed, including the discussions between Dr. Dinktwe and what is in the report, in whose custodianship it is and so on, all that was, we now know, sitting here, discussed in the recording that was played here, correct?
That's all that's contained in the Rule 53 record, Chair.
Exactly, that's my next issue. And that recording that was played here comes from the Rule 53 record, as you correctly say, which was supplied by the Public Protector, correct?
Yes, Chairperson. And it related to a date, 31 January 2019.
Yeah, whatever. No, the gist of my question is that Rule 53 record was supplied by the Public Protector. The thing that was played here, we wouldn't know about it if the Public Protector had not discovered it.
Well, that and the fact that on the 31st of January 2019, the Public Protector was in fact in possession of the report.
Yes, fine. I don't even know what you're trying to say.
Which was not in the Rule 53 record.
It was in her Rule 53 record with whatever you're saying. Okay, good.
It was not, Chair.
Yeah. Pardon?
The Inspector General of Intelligence report was not produced in the Rule 53 record.
I'm not talking about the report, Mr. van Loggerenberg. I'm saying the recording that was played here on Wednesday
yes, I've agreed, Chairperson.
Came from the Rule 53 record that was discovered or supplied
Correct.
by the Public Protector
Correct,
of South
Chairperson.
Africa, Advocate Mkhwebane.
Thank you. Let's proceed.
Thank you. All right. So she has a discussion about all these things, and then she, of her own volition, discovers it in the Rule 53 report. But let me just close up the following point, which might be important for another reason. If you go to 5.2.32, just to show the extent and lengths to which she went to try and get this report legalized, so to speak. She says at 5.2.32, and hopefully we'll get evidence on this when these witnesses are called. I have since requested President Ramaphosa's assistance in facilitating the availing of the declassified report by the Minister of State Security to no avail. You have no reason to dispute that she's lying about that.
No, in fact, it's reflected in the Rule 53 record.
Yes, thank you.
Chairperson.
Yeah. And then she says, this is the punchline which seems to confuse everyone, and which I will show you just now that the court was completely wrong and you about. Then she says, in light of the above mentioned, in other words, of all these things that you and I have now canvassed, and in terms of the powers vested in me by Section 181(2) and 3 of the Constitution, I have it on good authority that the findings of the OIGI report inter alia were that. Okay? And then A, SARS created a covert unit utilizing covert and intrusive methods, which was not in line with the SARS mandate and in violation of Section 2091 of the Constitution, which only empowers the President to establish any intelligence service. In other words, it established the rogueness, what I've called for shorthand, the rogueness of the unit. You agree with that? Not that you agree with the conclusion, but you agree that that's what she says is contained in the IGI report, correct?
Correct, Chair. It's actually a direct quote from the report.
Absolutely. Then she says, the establishment of an intelligence capacity within SARS, a capability exclusive only to legislated intelligence services, was illegal. Again, same point, rogueness, correct?
No, I only accept that what you're reading to me, Chairperson, is that it's a direct quote from that reviewed and set aside Inspector General of Intelligence report.
Yes. Mr. van Loggerenberg, please, let's try not to waste time. I've said what you're saying, that you don't, I'm not saying you're accepting the content. I'm saying you accept, okay, let me put it this way. Do you accept that if these two things are true, that would be a demonstration of rogueness? In other words, if SARS, in violation of Section 2091 of the Constitution, which only empowers the President to establish intelligence services, and the establishment of intelligence capacity, a capability exclusive only to legislated intelligence services, which is illegal. If that is the case, that's an indication of rogueness.
Yes, Chairperson, if SARS did that,
Yeah.
if it did that, hypothetically speaking,
Absolutely.
one way of describing it, I imagine, could be using the term rogue.
Yes, no, and I'm not doing it to be facetious. I'm using it as shorthand. Simply, as I said, maybe I'll use lawfulness, rather unlawfulness. Yeah, but you know what I mean. You agree with what I'm saying.
Yes, if it's your preference to then use another term, so be it.
Yes, because I just want to move on, Mr. van Loggerenberg. I don't want to quibble about stuff that is not going to assist this court.
Just a pause, Advocate Mpofu.
Sorry, Chair.
Honorable Maneli.
No, I just want, for purposes of clarity on my side, so that I know which report we're dealing with. The first point raised about the Kpmg report was more of a reference to the Inspector General of Intelligence. On this point, 5.2.34, is this a direct reference to the actual intelligence Inspector General's report, or it's still referred to as in the Kpmg? I think for me the important part is whether this then becomes an admission that you are using a report, whether acquired in one way or the other, or it's still referenced to Skakane, just to be sure that we're talking to the
I get
same point when we want to come back and ask questions. Thank you.
Thank you, Honorable Maneli. Advocate Mpofu.
Thank you, Chair. No, I get the point. Honorable Member, let me just, if we go back to 5.2.33, you see that it says, I have it on good authority that the findings of the OIG report inter alia were that. After that colon, up to the word activities at the end of 5.2.34. That's from the IGI report. Okay.
Chairperson,
Thank you. Yeah. So,
Understood.
thank you. Thank you very much.
Thank you. Just hold. Advocate Mpofu.
my apology.
Honorable Mulder.
On the same 5.2.3.2, please. If we can just have that there.
Which one? 5 point?
2.3.2. Yes. And 5.2.3.3. The point I'm trying to have clarity on is, Advocate Mpofu started off by asking Mr. van Loggerenberg this morning, where in the report does the public protector deny that she had a copy or have hold of the report of the Inspector General of Intelligence? That's what I heard, if I'm not mistaken.
Chair, if I may intervene, can I deal with the witness, please? I'm begging you. Otherwise, this is really going to derail my cross-examination. I can't be asking the same questions and then attempts to answer for the witness.
Let's allow him to complete.
All right.
Honorable Mulder.
Thank you.
That, Chairperson, I just want to make the point. This is not a jury. This is a committee that wants to understand the process. And if I want to ask and understand, then I would really want to be answered, but Mr. Mpofu doesn't want to be disturbed. So complete your, from my perspective, I'll ask you the question afterwards. Thank you.
Yes, thank you, Chairperson. The directives were adopted yesterday, and the directives say that the evidence leaders must lead the evidence, we must cross-examine, thereafter the members must raise their questions. There's a reason why it's exactly to avoid this kind of thing, where my cross-examination is being interrupted. I don't mind, I must say it openly, for clarity-seeking questions. For example, the one that Mr. Honorable Maneli, I know this is not a court of law, but what I don't want is to go into the merits of answers that I'm extracting from a witness, and because that's a completely different business, which is wrong. Thank you. Now, Mr. van Loggerenberg, thanks. So, anyway, when I was clarifying the issue to Honorable Member Maneli, I think that covered my next question, so I'm not going to ask you. Now, I'm saying, okay, after the word activities at 5.2.3.4, then it says the Kpmg report, right?
I'm not seeing it on the screen, Chair.
Okay, take it from me.
Yes,
All
okay,
right, yeah. All
I
right.
see that.
Yeah. Okay. Then, in other words, they're now dealing with something else completely. Now, it comes to the question which, as I say, has now been preempted, which I really don't appreciate. The question is, in the section that you and I have dealt with, we've now agreed that the discussion of the IGI report is for the reasons that we have explained, covered under the heading, the Skakane report. And this is now the end of that discussion. Now, I'm saying, where in this, what you and I have gone through, is this part where you say the public protector emphatically states that she did not have the IGI report? Where is that? And she did not see.
Just go up slightly, please.
I'm sorry, I'm very sorry to do this, Mr. van Loggerenberg. Let me put the question even in broader terms, and it will be clear just now why I'm. No, in fact, let me do this with your permission, Chair. In that spirit of killing two birds with one stone, go to paragraph 113 of the rogue unit judgment, so-called rogue unit judgment. Oh, it's bundle A, page 4016. Yeah. Got it. 113, please. Okay. Can I just carry on, Chair? It's a small thing. I'm sure when it comes up, it will come up.
Okay.
If I'm misreading, I'll be found out. Yeah. Okay. 113 says, this is what the judgment says. It says what you are saying wrongly, Mr. Van Loggerenberg. So the Public Protector relies on this report despite explicitly stating that she has not seen the report. Do you see that part?
Yes, Chairperson.
Yeah. And it says she relies on it because she has it on good authority that it was found in the report that. That part, the second sentence is correct. We've just established that. Okay? And then go to 1.1. I'm sorry, do you actually have a hard copy or any version of this? Okay, thank you. I think we're there. Okay, I've just read the first sentence and the second one. We can move on to 115. Can you see it, Mr. Van Loggerenberg?
Yes, Chairperson.
Right. Then again, the judgment makes the same point at 115. It says, despite the fact that, and I'm saying this at the back of your mind, you must understand this is all leading to a devastating finding that the Public Protector is dishonest. So, but pack that thought. Yeah. It says, despite the fact that the Public Protector, according to the report, underline according to the report, has never seen nor verified the contents on findings of the OGI report, she ordered the Minister to implement it within 90 days. The emphasis is on the first part. Despite the fact that the Public Protector, according to the report, not according to anything else, has never seen, in other words, they agree with you that she emphatically said she has not seen it. Yeah. Then 116, Chairperson. They say, it is difficult to understand on what basis these sections of the Constitution can notionally grant the Public Protector the power to rely on a report that she herself has not seen, because this is what she says in the report. So again, they agree with you. All right? The report, assuming, is the report of the Public Protector.
Yes, Chairperson.
Yes, and then it goes on and on. The thing about council, we don't have to deal with it now. Maybe I'll deal with it with Mr. Pillay, because he was a litigant. But go to 120. 119 first. The Public Protector now considered that despite explicit statement in the report that she has not had sight of the OIGI report in preparing, she has in fact had the OIGI report and in her possession when she drafted the report. The Public Protector now claims she subsequently received the report from an anonymous source who left it at her office. Firstly, that last one is just, she had said, we had in the conversation, that that had happened even before she went to see Dr. Dintwe, but that's not an important point I want to make for now. It's just factually wrong. But at 120, that's the punchline, which is before this committee. This turn of events is disturbing to say at least, and it is difficult to label the Public Protector's conduct in that regard as anything less than dishonest. In other words, the issue that is brought here before this committee to impeach the Public Protector is not the build-up, so to speak. It's the fact that she's dishonest. And that dishonesty owes to the fact that, according to you, Mr. van Loggerenberg, and this judgment, she explicitly, emphatically, whatever word you want to use, stated that she had not seen the OGI report. Now, here's the question. Where, can you assist this committee to tell us where in the report she has explicitly, emphatically, whatever you want to call it, stated that she had not seen the report?
If you can go back to the report, please, Chairperson.
Which one? The Public Protector's report?
Yes, Chairperson.
Yes. Which paragraph?
If my memory serves correct, somewhere around 15.2.23.
15 point?
Repeat that.
15.2.23. Somewhere around there. If I can just see that page.
Okay. We'll
okay,
get there.
2 and 23. Okay, it's on bundle A, page 4217. And 76. Are you finding it? Is that the Sorry, Mr. Van Loggerenberg, can you just repeat the paragraph you're referring to?
I think 15.23.
I don't think it's... Okay, I stand corrected, but I don't think the report goes that far, but let's just...
It's around there where she indicated she turned to the president for assistance.
Okay, no, you mean 5, yeah. Paragraph 5, there's no paragraph 15, yeah. Sorry,
Okay.
yeah, no, that's why I was totally confused, yeah. So, okay, sorry, no, it's fine, it's a mistake. So you are taking us to 5.2, the reference to the president is, you'll find at 5.2.23. Sorry. Blah, 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 blah. 32, yes, yes. Thank you. Okay, 5.2. Are you still with us, Mr. van Loggerenberg?
Yes, Chairperson. Can the person please just scroll up a little bit?
Please scroll up for Mr. van Loggerenberg.
The sentence starts with, in an attempt to verify the veracity, or something similar to that.
Okay, that would be.
There you go.
Okay, 27.
5.2.27.
Yep.
Just a minute, 129. So, okay, no, you can carry on. Sorry, I've just lost my.
Go ahead,
Just go ahead, I'll
Mr.
find it.
Loggerenberg.
Okay. So in July of 2019, Ms. Mkhwebane states in an official report under her office, position as the Public Protector, she states at 5.2.27, in an attempt to determine the veracity of the allegations of the existence and activities of the intelligence unit, I sought more information from the Inspector General of Intelligence, Dr. Setomaru Dintwe.
Correct.
This information was attributed to a report by the former Inspector General of Intelligence, Advocate Faith Hadebe. That then means emphatically that at that point in time, Ms. Mkhwebane doubted the veracity of the allegations, and she sought out to determine the veracity of that.
Can just try and repeat that? I don't know what you're talking about. You're saying
Well,
they.
in an attempt to determine the veracity, you don't need to determine veracity of something which you believe the veracity is when there's doubt.
Ah, I see. So, you are reading that to say she wanted to determine the veracity of the IHI report.
No, you're not allowing me to conclude.
No, take your time, Mr. van Loggerenberg.
Okay, just hold back, Advocate Mpofu. Please
we have
go ahead,
all
Mr. van Loggerenberg.
All right. So in July 2019, this process is described by Ms. Mkhwebane that there was an attempt to determine the veracity of the allegations of the existence and activities of the intelligence unit. That attempt was then to seek more information from the Inspector General of Intelligence. This information, which she sought to determine the veracity, was attributed to a report by the former Inspector General of Intelligence, Advocate Faith Hadebe. He stated that the report can be requested from the Minister of State Security. Now, if Ms. Mkhwebane had the report, everything that follows, subpoenaing the Minister of State Security, laying the criminal charges, writing a letter to the new Minister of State Security, opening a criminal case against the Minister of State Security, writing to the President and everybody else, is an emphatic denial that she was not in possession of that report. If she was, it would simply have said, I have the report, here's the report, this is what it said.
right. Are you done now?
Yes, Chairperson.
Thank you. So, what you've just said now is all that you rely on for your statement and the statements contained in the judgment that she explicitly and emphatically stated that she had not seen the report. Am I right so far?
Well, it continues. She then ascribes her knowledge and insight of the report to some kind of good authority.
Yes. Okay. Now, everything you've said.
And
Sorry.
Having said that, then my answer is yes, Chairperson.
Thank you. Thank you very much. So we know now it's those two issues that justify you and the judgment, saying that she explicitly and emphatically stated that she had not seen the report. Thank you very much. That's
Unless Ms. Mkhwebane is prepared to state that she did have the report all along. And then that begs the question why it wasn't produced to the affected parties, and why it wasn't produced in the Rule 53 record, and why the matter was opposed in the interlocutory, and whatever was stated on oath before court there.
right. We're going to get right there, Mr. van Loggerenberg. But I just want us to
It's
do...
not for me to, it's not for me to speak for Ms. Mkhwebane or for the committee.
No.
We do have a spokesperson.
Yes.
And Mr. Mkhwebane has you correct there. Thank you.
Yes.
Continue advocating both.
Thank you, Chairperson. And for now, I'm her spokesperson. No, Mr. van Loggerenberg, no. If we gave you that impression, we apologize. We just want you to speak for yourself. You are the one who says she emphatically said she had not seen the report. So you are your own spokesperson.
I've answered that question, Chair.
Yes. No, but so that other stuff was unnecessary. Just stick to answering the questions. So we've now established that the statement which is attributed to Ms. Mkhwebane, which has led for us to be sitting here because she is now dishonest, as far as you are concerned, is based on these two things. Paragraph 5.2.227 and 26. That's the good authority.
I don't think it's necessary to repeat, Chair. I've answered the question, and it will reflect in the record. I've said a few things.
Okay, I'm doing it for the record, Mr. van Loggerenberg. You don't have to be rude. Just work with me here. If I want to apologize, if I repeat it, I repeat it for a particular reason, if you don't mind.
Fine.
Thank you. Right. Now, I'm saying to you then that let's go to 5.2.27, the one that you say justifies your conclusion. Can you see that it says, in an attempt to determine the veracity of the allegations of the existence and activities of the intelligence unit? It doesn't say to the veracity of the report. Can you at least agree?
That was incorrect.
Agree on that? Yes. So, where in the world are you then finding that when she wants to determine the veracity of the existence of the unit, that has anything to do with whether or not she has seen the report emphatically?
Because the next sentence reads, this information was attributed to a report by the former Inspector General of Intelligence.
Yes.
Which is the report in conversation. The next question then is a response. Dr. Dintwe stated that report can be requested from the Minister of State Security. We've listened to the conversation. We've listened to how there were debates between the Inspector General of Intelligence and Ms. Mkhwebane on how exactly she could access it.
Yes.
On the 31st of January 2019.
Thank you, Mr. van Loggerenberg. Yes, that is so. But when we listen to that, and if it has to be played again, it will be played again. When we listen to that conversation, it was clear there, and I'm paraphrasing here, please don't quote me verbatim. You can just say you agree or you don't agree. It was clear. I'm just putting to you as a proposition. I'm just saying you can agree, disagree, or say I don't know. The proposition I'm putting to you is that it was clear from that conversation that the participants in that conversation were aware that, one, the report, the public protector, I think, said somebody had dropped it at the door or at the gate. I'm not sure which one.
But
The,
Mkhwebane, sir.
yes, that's Ms. Mkhwebane is the public protector, yeah. So what you call, Dr. Dintwe, I think, or again I stand corrected, or Ms. Govender said that in any event, it's in the public domain. Some words to that effect. And I think Advocate Govender made some other comments. And I don't know if this was... Yes, and I think, sorry, I was just verifying. There was even mention, but don't worry about this because we'll have to play the thing if we have to, even when you're not here. There was also mentioned by either the PP, I think it was the PP, that the report was actually in Noseweek, in a publication called Noseweek as well. Do you agree with that? Or don't you know, yes or no?
I don't know, Chairperson.
Good. Okay.
Yes, Advocate Mpofu, we'll pause there.
Thanks, Chair.
And take a tea break and be back at 10 to.
Thanks, Chair.
Thank you. It's a tea break, Mr. Johann van Loggerenberg. Please help yourself. We'll be back at 10 to 12.
Thank you, Chairperson.
Thank you.
Protector seeks assistance from the President. It's that entire section.
Okay. In other words, what you are saying is that, okay, now let me start it like this. You accept that what the Public Protector was saying ad nauseum in that meeting was that she wanted a declassified report.
Yes, I accept that.
Thank
I
you.
also accept that she said that possession of the report in any other fashion would be a criminal offence, and she considered it a serious matter.
Yes, yes. In other words, the possession of the declassified report, or rather, I'm sorry, of the classified report.
There was only one report at that point in time, and that was the classified report.
Yes, Mr. van Loggerenberg. Yes, Mr. van Loggerenberg. I'm saying that there was only one report, the classified report. That's why I'm confirming with you. And what was not, yeah, what was not in existence is the declassified report, which is what she was seeking from you. I'm sorry, from Dr. Dintwe, from the minister, and from the president. The declassified report.
Correct, sir.
Thank you. Yes.
If I can draw your attention to paragraph 252 of the judgment.
252.
252.
Okay. Let's go there. All right. Right. I'm there, Mr. van Loggerenberg.
It reads, but the demand made on the Minister of State Security to implement in totality the OIGI report dated 31 October 2014. And this is in the July 2019 Public Protector Report. That's one of the remedial actions.
Yes.
Firstly, the possession or use of a classified report would clearly constitute criminal conduct on the part of Advocate Mkhwebane,
Correct.
who as a former state security agency operative remains bound by national security and intelligence legislation. As stated above, a redacted version of the OIG report was declassified, but has subsequently been reviewed by the court. That declassification occurred post-July 2019.
Thank you very much. Yes. And that's exactly the point. So I'm saying to you, it is exactly for that reason that a public protector, a reasonable public protector, a conscientious public protector who has been placed into this possession of this document by a whistleblower, a real whistleblower, is at pains and taking all the steps to regularize and legalize the position. The meeting we listened to here, the sorry, Chairperson. Sorry, Mr. van Loggerenberg. I just want, Chairperson, I can feel that he...
No, sure, have a look. Look at it.
So now I even want to kill 3 birds with one stone.
Yes, but it's a
Yes. Sorry, Chairperson. Okay, I'm looking for, I'll refer the chair later to, when I say these efforts, you'll see in the section that I'm looking for where there's a list of this letter to this one, a letter to this one, a letter to the minister, a letter to the DG, letter to, and so on. I'm saying all those efforts and the meetings that you listen to here were an attempt by the public protector who's conscious of her responsibilities to regularize the position I'm sure you wouldn't quibble with that. Otherwise, she was just having these meetings for fun.
I don't know, Chairperson, is the proposition that that the public protector was indeed in possession of unlawful and illegal possession of that report. Is that the submission? Must I respond to that?
No, just, it's not your place to ask me questions. Are you wanting clarity?
He wants clarity, please.
Just
Okay.
clarity, please, Chair, sorry.
Okay, yes.
I apologize.
No, fine. No, I'm sorry, Mr. van Loggerenberg. No, let me simplify the proposition. The proposition is simply this, that all these efforts, and I've included the meetings, the public protector went to have a meeting with the Inspector General, that's common cause, trying to get this declassified report. So, she went to lay criminal charges against the minister. She approached the president. She wrote various letters. I'm saying all those efforts were in aid of regularizing the situation around the report.
I understand, Chairperson. I
The,
understand the question.
no, what do you think?
You're saying that you're in possession of something illegal and you want to make it legal.
Yes. You well, then the alternative is that all these meetings and letters and approaches to the president were just for fun. For
Yes,
lack of
that makes my point that of the evidence I led in chief, Chair.
I see. So that's your evidence. Okay, thank you. No, that's very clear. Now, so my next question is redundant, and don't shout at me for putting it. It's for the record here. Therefore, the sum total of your evidence is that all the issues that I've pointed to were intended, rather had no purpose at all. They were just play meetings and letters and approaches to the president and laying criminal charges against the minister.
I don't know, Chair. I think the committee must decide that once we hear the version of Ms. Mkhwebane.
I've told you the version of Ms. Mkhwebane. I've just told you that all those efforts.
Then let us leave it to the committee to adjudicate or to consider.
Yes, but the committee.
I don't want to express a view on something I don't know.
Okay. No, that's fair enough, Mr. van Loggerenberg. But the committee, it depends on you and I, it depends on the witnesses to assist it. But we can't force you, if you don't want to concede, or rather, well, you are doing worse than that. If you are denying that the purposes of those meetings were to achieve the obvious. But let me just say this.
Chairperson, I think the letters and the attempts speak for themselves.
Thank you.
There were efforts to obtain a declassified copy of the document.
Thank you.
That is, I think that's common cause, actually.
Okay.
The point I've always tried to make is the following point, and it's a very simple, narrow point. If the public protector was in possession of the report, unlawfully and illegally so, she did not save us at any stage. She then uses it to impose remedial action without providing it to those implicated parties. She also does not provide it to the court. That's the point.
Sure. No, that's fine.
How she got it is of less importance for me. I know she did get it because she says so in the 31st of January 2019 recording.
Yes.
She also says possession of it is a criminal offense.
Yes. She also said it in the meeting that we listened to. You remember? Where she
That's
said
the
it
same
was
meeting
dropped.
I'm referring to today.
Yeah,
Pardon?
that's the meeting he referred to. The recording.
Oh, I'm sorry. Yes. No, I'm talking the meeting with Dr. Dinto. Yes. And she.
So she had it.
Yes.
It's as simple as that. She had it.
Exactly. Exactly.
Now
But-
she wanted to use it and make it legitimate so that she could rely on it in her findings and remedial actions and the report.
Thank you very much, Mr. Van Loggerenberg. I couldn't have put it better myself. That's the.
But she issued the report prior to achieving that goal.
Okay, you're done. I just want to make sure because I don't want the disturbance between the two of you. You're done now, Mr. Van Loggerenberg?
Yes, Chairperson.
Thank
Okay.
you. Yes. No, thank you. I'm very happy with that. Yeah. That's what you're saying. It's kind of, would you agree, and again, I don't want to use legalese, that what you are doing now is to give us what is called is inferential reasoning. You're saying, if she did this and that and that, and therefore we must deduct this, you want us to infer something, correct?
I'm explaining the basis and the rationale of one element of my complaint.
No. We're not about your complaint here so far. We're about your conclusion that she emphatically said she had not seen it and explicitly
Yes,
said it.
correct,
Yes.
Chair. Yes.
Thank you. Yes.
You can
So,
infer.
are you finished, Mr. Van Loggerenberg?
Yes, Chair.
Yes. So what the proposition I'm putting to you is that your support for reaching that conclusion is based on the inferential reasoning that you have just explained to the committee, correct?
Yes, Chairperson.
Thank you. It's not based on anything that is explicitly or emphatically said. It's based on inferential reasoning, correct?
Yes, in the full conspectus of what I have testified about.
Thank you very much, Mr. Van Loggerenberg. We can move on. Okay, as long as we're clear on that. The next point that is made in the paragraph that just you took us to is what I call the Sangoma Point. So it will help us.
Chairperson, Mr. Mpofu began where we are now with number 2 of the big 5.
Yeah.
And he listed, we dealt with the Sikakane report, the Kpmg report, the Kroon press release.
Now,
and then he wanted me to confirm that the Public Protector also relied on the Inspector General of Intelligence report.
yes. Yes, no, that's where exactly you're 100% right, Mr. Well, that's where we are. What other point did you want to make?
No, in other words, at the time that she then relied on this report, she was in illegal possession of the report.
Yes.
That's my point.
Yes, she was. Technically speaking, she was, yeah, in the sense that that's exactly why I've been at pains. Maybe it means then, since I've been trying to tell you that she was trying by all these methods to regularize, or let's say legalize that possession.
I understand.
That she was playing.
I
I understand. Yes. No. So we're clear now. Are we clear with each other?
I think so, Chair.
Thank you.
I hope so.
All right. Yeah, I hope so too. So we can go to the Sangoma Point. Now, I'm saying to you, as far as the... Okay. I'm sure I don't have to say to you that she cannot be impeached for not being a Sangoma. But as far as the second sentence that you raised in the... you took us to paragraph 252. This is what it says. As stated above, a redacted version of the OIGI report was declassified, but has subsequently been reviewed by the court and set aside.
Yes, Chair.
Yes. You would agree that that statement is completely unrelated to the report. It cannot be logically to the, sorry, there are so many reports we have spoken about, to the Public Protector's report. Unless
don't
if
know,
you-
Chairperson, I don't know.
No,
all I
I'm
know
saying-
is that,
okay.
Had Ms. Mkhwebane engaged with me, had she put that report to me, one of the first things I would have done is taken it on review. I didn't even know it existed.
Yeah, but if is not going to help us. Let's talk facts, Mr. van Loggerenberg. I'm saying to you,
It's a fact.
sorry, are you laughing at me?
No,
No, not at all,
no,
Chair. You said it's a
no, he
fact.
says it's a fact.
Okay. Okay. I thought maybe I said something funny. No, what I'm saying is you would agree that this part about the declassification and review happened in 2020. Yes?
I'm sorry, Chair, I just lost some audio there.
Oh, sorry, Mr. van Loggerenberg. I'm saying you would agree, I'm sure, having been the applicant, that the review of that report happened in 2020.
I commenced in 2019 and the conclusion was in early 2020, correct? Yes. Chair.
No, it was on the 8th of June 2020. That's when you obtained your order.
Correct. But I initiated,
Yeah, I'm not talking about initiation, I'm talking about the review. It was reviewed and set aside on the 8th of June 2020. Surely you understand that,
yes, I understand that.
and you accept it as correct.
It is correct, Chair.
Thank you. Now, I'm saying unless Advocate Mkhwebane was a Sangoma, she wouldn't have known in July 2019, at the time of issuing the report, that a year later it was going to be reviewed and set aside. I'm sure we agree at least on that.
I'm sure, Chair.
Pardon?
Yes, Chair, I'm sure.
Thank you. So that's what I mean when I'm saying she cannot be impeached for not being a Sangoma. Then all of us must be impeached. Okay, thank you very much. Right, next, so that's the IGI report and the false. That's the audit thing, yeah. Okay. Then the Public Protector, and thank you again, Mr. van Loggerenberg, because you reminded us of where we were on the list. It's just that this one is very important. It actually helps with number 3 and even number 4 of the Big Five. So again, we've made some good progress.
So
But-
you achieved 2 beds there.
But
You achieved 2 beds there.
3.
Oh, okay.
3, Chair. We're 3. I think we're on 4 beds now. Yeah.
Go ahead.
Thank you, Chair. So so with the Kpmg Report, Kpmg crew, and we're on the IGI. Then, of course, the Public Protector had also relied on an interview she had with Mr. van Rensburg, one of the members of the rogue unit, correct?
No, Chairperson.
She did not have or rather a recording of Mr. van Rensburg's interview. I said, if I said interview, I meant it in recorded form. Sorry, I didn't mean to mislead you. You accept that she relied on the interview with Mr. van Rensburg?
She relied on a partial recording of Mr. Johann van Loggerenberg and some unknown person.
Yes. Thank you. And Mr. Johann van Loggerenberg was your co-accused in the criminal trial, correct?
That's correct, Chairperson.
Thank you. And both you and him were charged for the activities of the alleged rogue unit, correct?
No, Chairperson.
You were charged for other crimes. alleged.
Yes, Chairperson, I was charged for supposedly somehow allowing the National Prosecuting Authority to pay one of their service providers an amount of approximately 100,000 rand improperly.
Right. And did that not include the issue of the installation of cameras at the NPA?
It was money paid to the service provider by the NPA.
Yes, that's what I'm saying. That you are charged for things related to the illegal interception of or spying on the NPA.
No, Chair, I've just explained to you. I was charged for improperly allowing or inducing the NPA to pay a service provider an amount of approximately 100,000 rand.
For what? For the spying equipment?
For their installations of their equipment.
Yes. Thank you.
It had nothing to do with the unit.
Nah, don't worry, Mr. van Loggerenberg. I'm not interested in those minor details. It's insufficient for me to say that you are charged for activities related to the installation of spying activities at the NPA and equipment related thereto. That's fine. Okay, you happy with that?
I've answered you, Chairperson.
That's fine. You don't have to answer it again. All right. And then the public protector, where are we now? 1, 2, 3, 4, 5, 6, 7. And the seventh set of information that she relied on was, again, a recording of Mr. Lombard and Duval, who were also former members of the rogue unit, correct?
She relied on a partial recording of a conversation between Mr. Moyane and Mr. Mapakwa. Mr. Helgard Lombard, who was a member of the Special Projects Unit, period February 2007 to April 2008 only, and Mr. Duval, who is a member of the unit in its different conventions until it was shut down in October 2014.
Good. And among other things that they said was the confirmation or the information about spying on the NPA allegedly in relation to the Silebi matter to give information to President Mbeki, the thing that we dealt with yesterday, allegedly.
I think I've answered you on that, Chair. It's a very confusing conversation.
But something like that.
Yes, it seems to me that the DSO actually bugged themselves, each other.
They bugged themselves. Okay, thank you.
Yeah.
All right. Okay. Then the next piece of information she relied on were the documents submitted to the Public Protector in 2014, long before Ms. Mkhwebane even got there, in relation to the complaint of Mr. Manyike, another member of the rogue unit, correct?
No, that's incorrect, Chairperson.
Which part?
Mr. Pizorski Manyike was never a member of the Special Projects Unit, the National Research Group, or the High Risk Investigation Unit in any manner or form.
Okay.
Contrary to what the report states.
Okay. But he was aware of its activities, and he even made a televised, even I saw it. It's the gentleman was a Rastafarian who made a televised account of the activities of the rogue unit and was insulted by the Sunday Times as just for his religion. Is that the man?
I don't describe him like that, Chair, and I disapprove of a description like that. I used to get along very well with him. If you say so, all I can recall in the report is that Ms. Mkhwebane relied on him in what she described as a former unit member, which is factually incorrect. And I dealt with all of these claims on oath, which forms part of the court record and that was settled before court. In terms of the interview on television, I've also seen parts of it.
Yes.
I actually asked for a right of reply, and we were going to have a one-on-one session live on television, but he withdrew it last minute because he said the matter was sub judice.
Yes. Well, at least he observes the sub judice rule. Yeah. So, okay. No, fair enough. And just for your information, I've just been corrected and taken instructions. The position is that, and if you know, you know. If you don't know, you'll just say you don't know. Is that Mr. Manyike was actually representing members of the rogue unit. He was basically speaking as a union person. But we don't have to, if you don't know, we don't have to be bogged down with that. We'll have evidence around that.
Well, the report doesn't say so. The report says that his evidence was accepted as a member of the unit.
Yes. I don't want to go to that, Mr. van Loggerenberg. Otherwise, we're going to have to, I can tell you that road will end us at the place where we have inferential reasoning that is oblique and indecipherable and gobbledygook. Okay, so
as long as it's clear to the committee, Mr. Bezowski Manyike was never a member of that unit, and he knows nothing of that unit.
yes, no, fine. That's what I'm saying. I don't want to quibble with those issues.
Just a pause, Advocate Mpofu. Honorable Sukas.
Good morning, everybody. Chair, I just want to point out Mr. Mpofu's now called twice the rogue unit, and I think the witness has said that he is not comfortable with that when he started.
No, that's fine. Would have established that he chooses to call it rogue unit. And there shouldn't be a problem. Mr. van Loggerenberg has indicated here that it was a high investigating unit. So let's just deal with that in that way.
Thank you. Yes, I thought we sorted that out on day one when me and Mr. van Loggerenberg, not with you. Yeah, we sorted it out between me and Mr. van Loggerenberg that I will continue to call it that. He calls it the high risk unit or whatever. I even said at that point, for the purposes of
unit,
that question,
call it a unit.
The unit,
Yeah.
and then I'll be thinking rogue unit, and he'll be thinking
Because you have rogue, you'll always
Yes.
think of rogue.
Yes.
Continue.
And I've been saying it so many times that I'm not saying it to be facetious, or it doesn't mean I'm going to turn around now at the end and say, Mr. van Loggerenberg called the rogue. Oh, by the way, yeah. When we are on that, when was does the rogue unit still exist, Mr. van Loggerenberg?
I don't know of any rogue unit, Chair.
Is that your answer?
Which unit are you referring to,
All right.
Mr. Mkhwebane?
Now, you know, Mr. van Loggerenberg, the problem with the witness who just grabs anything is this. You were asked this question, this very question I've just asked you. Does the rogue unit still exist? In an interview with Mr. Aldrin Sampier. You remember that?
No, I don't remember that, Chair.
Do you remember doing such an interview on Power FM?
Yes, I do, Chair. It was
Yes.
some years ago.
Okay, I'll remind you. You were asked this question, and we have sent a copy of the interview to our learned friends. We're not leading it now, Chair, but if the witness denies, then we will. It doesn't need him, so we can have that debate some other time.
Can I maybe?
Okay.
Just to place it on the record, it was emailed to the secretary this morning at about 8:30. I haven't listened to it at all.
Okay,
Thank you.
that's fine.
Thank you very much. I'm saying, and again, Mr. van Loggerenberg, I'm saying it's just for the sake of progress. If I'm misrepresenting you or whatever, I will be discovered and impeached. So you were asked this very question, does the rogue unit still exist? And this was your answer. No, it was shut down by Tom Moyane in 2014. You remember that?
I don't, but if you say so, I'll accept that, Chair.
Yes, that's what I'm saying. For that time, there was no one to say, you must not be asked a question using when was the rogue unit, whether it still exists, and you answered the question.
Yes, Chairperson, that was a radio interview.
Yeah, no, fair enough. I'm sorry, Mr.
There's a little bit of a difference for me personally in respect of that interaction and this particular platform
Yes.
or the Office of the Public Protector.
No, fair enough. No, in fairness, Mr. van Loggerenberg, you're not the one who objected. I think you and I understand the context in which I'm using that word, but I was just showing that how this thing of trying to hide behind semantics is not going to help anybody, because you yourself, in this context, accepted that it is called the rogue unit. By answering that question to Mr. Sampier, it doesn't mean that you, Mr. van Loggerenberg, are now adopting what you call the rogue unit narrative. Nobody in their right mind would think that you are now no longer denying the quote-unquote rogueness of the unit, or at least not me. I was just illustrating that point. And believe me, I'm not making that point, that simply because you answered this, now suddenly it means you are saying it's the rogue unit. That would be ridiculous.
I promise never to refer to advocates as rogue advocates.
Yes. Well, if are you trying to be coy and funny, Mr. Loggerenberg, so that we can laugh at the right time? Pardon?
Sorry,
No, Chair.
Chair.
Okay.
If I may, Chairperson.
Thanks.
Honorable Mylam.
Chairperson, once again, I need to object to the tone and manner in which Advocate Mpofu is addressing the witness. We agreed in the directives that witnesses would be treated with dignity and respect. And that is not the case in the way that Advocate Mpofu is addressing the witnesses. In fact, I find his behavior, and I said this yesterday, towards this committee and towards the witnesses to be aggressive, to be disrespectful, to be interrupting, to be arrogant and dismissive. And I'd like to put it on record that Advocate Mpofu needs to start learning how to interact with Parliament. This is not a court of law. There's no grandstanding here. We are here to find the facts. We are here to determine whether or not there's any truth to this. And that's what we are working towards. Now, Advocate Mpofu, please, I'm going to beg of you, please just let's try and stick to the facts, let's stick to the point and deal with it appropriately. The way that to accuse a witness of being coy or misleading or whatever it was that you said you used facetious earlier, that's not acceptable. That's not acceptable. If we want to ask a question or if we want to take it further, we will. But please give this committee and the witnesses before it the respect that they deserve.
Thank you.
It's the very least we can expect it.
Thank you, Mr. Mylam. You have made your point quite clear.
Chair.
Thank you, sir. Can I?
Is there somebody in the virtual?
Yes.
Yes. It's me, Chair.
Okay, go ahead.
I think this committee has got a chairperson, and that if Advocate Mpofu or any of us are not consistent with the directives, it is well within the chair to bring us back into order. It is going to be very abusive for people to abruptly just stand up here and tell us their feelings. It's not like we're all feeling the same, but we subject everybody in the process here into the capable hands of the chair. So please do not allow that, Chair. That people must just, when they feel hot, stand, raise hands here to tell us they're feeling hot. It's not going to happen like that. As long as you have not said to the Advocate Mpofu you are out of line or anything of that sort, Advocate Mpofu is in line and should be protected by you, the chairperson. Thank you.
Thank you, Honorable Malema.
Thank you.
Before I acknowledge you, Advocate Mpofu, I want to repeat again what I said earlier, that I request that you tone down. You don't have to, because we can't change who you are in terms of how you ask your questions.
Yes, you can't.
But I did indicate that I will invoke the directives when I get to that point.
Yes. Yes, Chair, I think...
Please continue with the witness.
Okay. No. I have to respond. You've just made remarks to me, and someone has just insulted me and of grandstanding. So I've got to, please, if you don't mind, Chair, just respond to that.
I would not want us to stay at that
No,
point,
but
but
then-
you can make your brief point,
Yes,
but I don't
thank
want
you,
us
Chair.
to,
Yeah.
to be
Thank-
sidetracked
Thank you, Chair.
in this
Chair,
meeting.
Chair, Advocate Mkhwebane and me are entitled to respect as well. If that is not so, then at least me, I will stop participating in this committee, because I'm assuming that as much as respect is expected for me, it must be given. I'm a citizen of this country. The fact that you are a member of parliament doesn't make you, actually you are my servant. I'm a citizen, all right? So I'm not going to be here to kiss the feet of anybody. I'm here to respect people, and then they can respect me back. Then we're fine. But I'm not going to be insulted and be called grandstanding and all those things and keep quiet. I will never do that, never.
Thank you.
I'd rather die.
Thank you, Honorable People.
All right.
I think you've covered the point.
All right.
Because
So,
I certainly
thank
would
you.
not share any kissing of feet.
Yeah. No,
in
it's
this.
not going to happen.
Please proceed.
Thank you, Chair.
White privilege sucks, Chair. It's white privilege.
Just pause, Honorable Advocate Mpofu.
Thank you.
Honorable Mautwe, I'm going to ask you that you don't do what you're doing again. Members here get to be recognized to speak. If they raise a point of order, I recognize them. I am not going to allow you to continue doing the things the way you're doing. Please refrain from that.
Thank you, Chair.
Advocate Mpofu.
Thank you, Chair. Thank you, Chair. Mr. van Loggerenberg, and also, Chair, let's be even-handed. The reason why I was asking Mr. van Loggerenberg that question is because he was being sarcastic. And nobody here, not the honorable member, not the chairperson, is intervening. So I have to intervene for myself, to protect myself, all right? And I'm going to do that until the last day of this hearing. Because nobody here talks about the fact that Mr. van Loggerenberg has referred to a rogue advocate. Who is the rogue advocate? Who is the rogue advocate? And I must respect that.
Okay, thank you, Advocate Mpofu.
Anyway, all right. Mr. van Loggerenberg, can we go back to the business?
Yes, Chairperson, can I just apologize to Mr. Mpofu?
Accepted.
If he mistook, I certainly did not mean to insult him.
No, that's, I accept that, Mr. van Loggerenberg. Thank you. Let's just get back to the business of the day. So, but thanks for assisting me just to put certain things in perspective. Okay. Now, I was then saying that those 8 things, 1, Kakane, 2, Kpmg, 3, Kruan, 4, IGI, 5, Van Rensburg, 6, the PP report itself and her investigation, 7, De Waal and Lombard, and 8, Manike, were the sum total of the material that the Public Protector took into account. I think we're clear on that. Subject to, obviously, you've said this one must be qualified this way or whatever. But those were the materials, correct?
I think more or less, yes, substantially,
Yeah.
Sir Chairperson, which brings me to one of the points that when we opened this morning, I asked the Chair whether I could raise certain things. There's one item that would fit into this conversation, if I may just raise that particular one, Chair.
Yes, your points in the air.
Yes. Chair,
Yes, it concerns then, it fits in with what Mr. Mpofu has just asked me.
Okay.
That
yes, thank you.
what Mr. Mkhwebane relied upon in concluding report 36 of 2920.
Okay, I will allow you to do that. He seems to want to complete something.
Yes,
and then you bring that
thank
as
you.
respond.
Thank you. Sorry, Mr. van Loggerenberg. I don't mean to interrupt you, but I'm just for progress.
Sure.
Yes, you may raise that point and even your other points, just in case I need to deal with them, so that I don't have to come back to you. Yeah, I think it will be better that way. Thank you.
Go ahead,
Okay.
Mr. van Loggerenberg.
Thank you, Chair. So yesterday, in questions posed to me, and there was a bit of a haggle between Mr. Mpofu and I in respect of what he referred to as primary targets of the investigation, and I preferred the term implicated persons, and I think ultimately we agreed to use the word prominent persons. I've reread the report, and on my rereading last night, the following people are targets, prominent or otherwise, the preferred term for me would be implicated persons of the report. Mr. Gordon, Praveen Gordon, Mr. Ivan Pillay, Mr. Opa Mahashula, 26 civil servants that were over the years of its existence members of that unit. Mr. Johann van Loggerenberg as the manager of that unit in year one of its existence. The manager of the unit for the 9 months in 2012 when I did not oversee it. Me as the manager for the bulk of the period of its existence. And in respect of the remedial action, another person, Mr. Pete Richer, which totals 33 targets or implicated persons or whatever terminology one would prefer. Of these 33 persons whose rights were affected by the report 36 of 2920, only the first 3 were served with Section 7(9) notices or heard by Ms. Mkhwebane. None of the others were. What would make the one more prominent than the other one, in my view, would likely be their public profile or their seniority in terms of their current or erstwhile ranking as civil servants, in my own view. And this issue speaks directly to my complaint, because the issue for me is not the merits contained in Report 36, by and large, about which I'm currently being questioned, because they've been dealt with before courts and other platforms. The issue is also not my conduct. The issue is not anybody else's conduct before this committee. The issue speaks to the absolute part of my complaint, and that deals with the aspect of that I say that Ms. Mkhwebane failed to conduct the investigation without prejudice. It is the conduct of Ms. Mkhwebane that is being considered by this committee, as I understand it. That was the one point, Chairperson. If I understood Mr. Mpofu correctly, he suggested I should deal with all the points now. Chair?
Yeah, go ahead.
My-
Yes, proceed. Yes, you got him correct.
Okay. The second item that hung in the air was this issue about without fear or favor or prejudice. I went and found the quotes. On day one of my testimony, which was day 2 of this committee's hearings, on the recording at 2 hours and 5 minutes, somewhere from around there, I say the following. I say an investigation was conducted, and in terms of the Public Protector Act, the person who occupies that office, who happens to be Ms. Mkhwebane currently, did not have a choice. She had to contact me and afford me sight of what the claims were, and she had to conduct an investigation without fear or favor or prejudice. She failed to do all of those things, and that is my complaint. It's really that simple. I wasn't heard once again in all of the saga. I was simply disregarded as if I didn't exist and was completely irrelevant. Then yesterday, which was my second day before this committee and the third day of the hearings, at the recording at about 19 minutes, I am very specific in my response to the question posed, where I deal specifically with that the essence of my complaint is restricted to the prejudice element of the fear, favor, or prejudice. I restricted my complaint, therefore, to prejudice so that the committee is clear on that. Where I did refer to without fear, favor, or prejudice yesterday at my second appearance, I specifically quoted from a court judgment and from my affidavit in a general sense. And then I specifically made the point that in my case and in my experience, Ms. Mkhwebane did not act without prejudice. And that is then the essence of my complaint again, which I reiterated. So that is the second point, Chair. On this issue of the use of the term rogue as opposed to so-called rogue, I don't want to rehash the debate that's just been had between the members of the committee and Mr. Mpofu as the evidence leader. I simply want to speak to what is directly related to my complaint, and that is that Ms. Mkhwebane, in her capacity as the public protector, who was still busy conducting the investigation, used the term rogue. She also used the term so-called, as Mr. Mpofu pointed out, but she used the term rogue on multiple occasions, and I gave 2 examples of repeated references which occurred prior to the conclusion of Report 36 of 2019-20. I did not mislead this committee as suggested by Mr. Mpofu. Those 2 instances that I referred to, and there are actually more, but the 2 I referred to in evidence was the YouTube video and the Inspector General of Intelligence interview. And that speaks also directly to the essence of my complaint, which is that the process was concluded not without prejudice. There are 3 ancillary issues which were also left hanging in the air, Chairperson. One is the question of, I was asked why I approached this committee as a whistleblower. Section 1 in the Protected Disclosures Amendment Act included the words in section 1 under the definition of employee. It now includes the words or worked. So it's a person who works or worked, past tense. In other words, a former employee. And I accept the shortcomings of the Act. I say so in my paragraph 3 in my submission to this committee, but I still seek to assert my status as a whistleblower, and my paragraph 3 expresses that clearly. I was asked about my so-called psychological condition by Mr. Mpofu. I'm not ashamed of it. I've never hidden it from anybody. It's not something I walk around on my sleeve. I'm fully compos mentis. It's something that's very treatable. The World Health Organization has found that 1 in 8 people, statistically, have been diagnosed with one or other similar affliction in the world, which statistically means on this panel today, I'm not the only person potentially suffering from such a condition. And I sought help and I received treatment many years ago in my 20s. The reference to it, though, in my view, emanates from what I described in my chief evidence as the propaganda campaign, because one of the initial personal attacks before the notion of this unit was conjured up was that I was supposedly mad, mentally ill, psychopath, etc., which is all nonsense. The medicine, in inverted commas, which one committee member, for some reason or another, thought was whiskey, is in fact a combination of alcohol-free antiseptic, some supplements, aspirin and water, and probiotics, because I'm on antibiotics, because I had a bicycle fall in a contest I participated in, and undergoing major reconstructive surgery on my jaw and teeth, which will take many, many months. And that explains why I'm mumbling and sometimes appear to be in pain or discomfort. Thank you, Chairperson.
Thank you. Thank you very much, Advocate Mpofu.
Thank you, Chair. Yes, thank you, I suppose, Mr. van Loggerenberg. When it comes to your, well, firstly, just to correct you, you just promoted me to evidence leader. Now, I'm not the evidence leader. I'm just a lowly rogue advocate, according to you. So,
I'm sorry, Chair.
Don't go back to that rogue, please.
Yeah, no, it's fine. Okay, then the next question about the 5 minute, which ended up being 33 minutes, the 5 minute YouTube transcript, that rather extract that was played here, is, I've just done a quick transcript of it. This is where the high water mark of your accusations is that Ms. Mkhwebane used the word rogue unit, not qualified by so-called, in the way that we've just had that small debate earlier, in the way that you used it at Power FM. But I just want to be sure that that whole exercise, its intention was about this. She says in the clip that was played here, our investigation of Minister of Public Enterprises, there were allegations that were harassing him, and issued a subpoena or yes to him requesting information about several investigations which we're conducting. And she says the first one is the pension payout of Mr. Pillay. Let's jump that. And then she says at the part that I think is the one that you want this committee to use to impeach her. She says, I don't go around and ask people to complain. Therefore, when I receive complaints, I will also have to approach the persons who complained against the request, their side of the story. And we all know that the EFF complaint was dealing with the rogue unit in the process which have been followed. Their recruitment, the procurement of equipment, their operations. Another complaint was relating to complaint under the Executive Members Ethics Act, which they were alleging that Minister Godan lied in Parliament about his meetings with the Guptas. Is that the offending part?
Yes, Chairperson. I think the quote is in the letter.
Yes, that's what I'm saying. In other words, the fact that she was referring to the EFF complaint about a rogue unit means that she must be impeached?
No, Chairperson, I think yesterday I clarified. I'm not in any position to demand anything from this committee.
Okay.
So I've never called for impeachment.
No, fine.
Yeah.
I'm sorry, but you said she's not fit and proper. Is that one of the reasons why she's not fit and proper?
Within the conspectus of my complaint, yes, Chairperson, it adds up.
Okay, thank you. All right.
Also, the reference to the people that died and will likely die or something to that effect.
Yes. She said, yes, the part that is your other proof that she's not fit and proper. Yeah. So in that part, she said, I'm also still I know one will be faced with lots of questions. In fact, there will be a lot of questions. There will be allegations that I'm also persecuting Minister Godan. But I'm doing my work. And I understand that when it comes to the issue of the rogue unit, people have lost lives and have been tainted. And I think that is still going to happen, but I'm going to do my work. She's not fit and proper because of that as well, correct?
Okay, my complaint speaks to not acting without prejudice.
All right. Thank you. So,
thank you.
Just answer the question, please. So, because she says people have lost lives and people have been tainted, are you not one of the people who have been tainted by these allegations?
Absolutely.
But she's not fit and proper for pointing that out.
Chair, I've just answered. It's not a simple reduction as being put to me. In my evidence, I'm trying to portray to this committee that if a public protector approaches a complaint and an investigation with an open mind. Now, in this case, the EFF said, here's a unit that's rogue and did all sorts of horrible things, and that's why it's rogue. Please investigate. Then you don't perpetuate that label, because that suggests you don't have an open mind. You're not, that's my point. Now, you may agree with me, you may disagree with me.
Okay.
That is the point I'm making.
No, good. No, I understand the point, yeah. For the record, I disagree with you. But the point I was making now was the other reason why Ms. Mkhwebane or Advocate Mkhwebane is not fit and proper is because she said people have been tainted, including you.
No, I believe she's not fit and proper because of the elements of dishonesty and the fact that she did not conduct the investigation in the manner that she ought to have.
Yes, but one of the, I was trying to say to you here, we had a tussle, let me call it that. I was telling you, please go to paragraph 3. No, I want to go to paragraph 1. Go to paragraph 3. No, I want to go to paragraph 1. Because of this. Because she said people will be tainted. That's what I'm saying. Is that for that conclusion, among other things, it is the fact that she said people are tainted, including you.
Yes, it's part of the sentence and it should not be read in isolation,
Okay.
but in the context of the entire sentence.
Good. I'll read the whole sentence, and then you must tell me which part. It says, I know one will be faced with a lot of questions. In fact, there will be a lot of questions. There will be allegations that I'm also persecuting Minister Godan, but I'm doing my work. And I understand that when it comes to the issue of rogue unit, people have lost lives and people have been tainted. And I think that it is still going to happen, but I'm doing my work and I will be serving that notice today, which is the 2nd of June 2019. In fact, it's the 3rd of June 2019, and I'm ready to receive all the backlash, but I'm doing the work. I'm not targeting or harassing any minister or specifically Minister Godan. That's the full sentence. Which part of that suggests that she's not fit and proper?
I've answered the question, Chair. There's nothing more I can say.
No, Mr. van Loggerenberg. You said I'm reading half of the sentence. I've now read you the full sentence. How can you have nothing to say?
It's contained in my annex to JVL 3, in my affidavit before this committee, the specific sentence. The sentence is, when it comes to the rogue unit people have died, or people have been killed. People have been tainted. That can only mean one thing. I don't know what it means to you, Chairperson, but to me it means there's a rogue unit, they've killed people, they've tainted people, and they're going to likely kill more people and taint more people. That is biased. That is prejudice.
Thank you, Mr. van Loggerenberg. I think you've responded to the question. Advocate Mpofu, maybe before you proceed, just pause, Honorable Mulder.
Thank you, Chairperson. Now, it seems that the exact wording that was used in that interview is going to be rather relevant. Could I ask that the committee also receives a copy of the printout of the exact wording in that? Doesn't have to happen at this moment, but could we please be furnished with that?
Yes.
Thank you.
Thank you, Chair. Yes, no, that's easy. We've already done a transcript. All that we will do, we'll send it to our colleagues. Once it's agreed, then it will be circulated. Thank you. You said in your interview on Power FM that the people had died or lost lives. Sorry, I can't remember the exact wording. What were you referring to?
I don't know, Chair. If you can give me a transcript or allow me to listen to the interview again. I remember meeting Mr. Sampia. I remember doing the interview, but I don't recall specifics.
Okay. No, that's fair enough.
If you have it with you, Chairperson, Mr. Mpofu, if you can read the question to me and my answer may assist.
Sorry, no. That one is quite long. That's the one I said to the Chair. I promise, otherwise we were going to have another 1 hour listening. Yeah, we will.
What I can say is what I have said on occasion, Chairperson, is that the trauma caused as a result of these events have almost caused people to die. I've had to attend to families where people attempted to commit suicide.
Yes. But when the public protector says the same thing, that people have died for whatever reason, trauma or whatever, that means she's not fit and proper.
I read that sentence completely different, Chairperson.
All right. So, and then you said in your affidavit in support of Mr. Pillay, at paragraph 6.5 thereof, that this unit was utilized in investigations where there were a real or present and anticipated threat to the lives, safety and well-being of other investigators in the units listed. To SARS as an institution records evidence and investigation, and in instances where other investigators declined or requested to participate in aspects of certain high-risk investigations for fear of their lives and those of their families. Is that still your evidence?
Yes, Chair.
All right. Thank you. Just as an aside, you and also I think the judgment alludes to this, and you started with this in the morning, I think on day one or probably when I started the cross-examination. Sorry, I stand corrected. And if I'm misrepresenting you, you'll explain. But you did say that some of the information about the rogueness of the unit came from disgruntled and disgraced employees. Words to that effect. I'm not quoting you verbatim, but do you know what I'm talking about?
Yes, Chair.
Thank you. Now, by that, I suppose it stands to reason you are suggesting that information from such people, and I think we said one of them was involved in rhino poaching, that information from such people must be taken with a pinch of salt, correct?
No.
Pardon?
No, Chair.
You were just telling us for the love of the country. But
No, I think one must, when somebody in the position is those two of those people, there are more, but the two primary ones, who also happen to be state security agency operatives, or were at some point in time. One must always look at the motive. It does not automatically dismiss the value of the evidence, but one must look at the motive. And then one must look at the veracity of the evidence provided.
Agreed. On that, Mr. van Loggerenberg, I can hire you to be part of my team, especially when disgruntled employees are going to be called here later on. But the point I'm making is that point is also made in the judgment at paragraph 183, where it says that criticizing the public protector. Blah, 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 without paying any regard whatsoever to what Mr. Pillay said in his second affidavit dated 18 October, June 2020, namely that the author of Operation Snowman was Mr. Pierre, alleged to be a disgraced and disgruntled former SARS employee. You remember that in the judgment?
Yes, Chair.
And you've already answered my next question, that such evidence must be taken with a pinch of salt, in the sense that the motive might be not so holy, correct?
In this case, it's a little bit more nuanced, Chair. Firstly, Mr. Picha has owned he's claimed ownership of the document, and in fact, he provided the document to certain people way back in 2009 and early 2010 and onwards. What preceded the drafting of that document was what I referred to as what they called Project Broken Arrow, of which some people who were asked to participate in crafting that document way back in 2009 reported this to the Revenue Service, and they reported dates of meetings and what the intentions were and so forth. In a nutshell, it was described as there are going to be efforts to discredit and cause havoc and target Mr. Gordon and Mr. Pillay and the unit and myself in particular. And so it was kind of, let me call it, there was like an orchestrated plot in order to create this dossier, which was then intended to be given to the then president in the hope of achieving certain nefarious outcomes. So we know this because this was the evidence put before court, and we know what the motive was of Mr. Picha at the time. In fact, he himself has explained that on occasion. So all I'm suggesting, Chair, is that one must have account of when somebody makes a claim, one must take into account the motive of the person, which should not automatically exclude the veracity or validity of the evidence, but one must have it in mind, and then one must deal with that evidence with the necessary circumspect.
Thank you, Mr. van Loggerenberg.
Thank you.
We're
Thanks.
going to pause there for the next 45 minutes and take lunch.
Okay.
Back at 1:45.
Thank you, Chair. Yes,
Thank
I
you,
was
Chair.
actually going to move to another topic, so that's fine.
Thank you.
Recording stopped.
We'll meet you at 1:45, Mr. van Loggerenberg.
Thank you, Chair.
I'm just going to leave it on the charger
To pick up the No.
I just want us to deal quickly with two issues in the time that, and I'll do them quickly. Well, it's in your hands. If you will either do them quickly or not. Yeah. The issue of the equipment. Sorry, just a minute. Just want to check if a certain document was sent to my colleagues. Okay. Sorry, Chair, I'm sorry to do this through you. Ms. Bauer, there's a letter that we sent to you. It's a short letter. If you can just have a look, and then you can indicate to me if you are happy that I won't do it now, but until you've indicated that I can refer to it. Thanks. Thank you, Chair. Okay, no, let's leave that for now, Mr. van Loggerenberg. Maybe we'll come back to it. You do accept. Oh, okay, no, maybe accept is a strong word. Yeah. You do understand that the Public Protector's approach and conclusions and findings are that the unit was rogue, among other things, because it breached the intelligence legislation as well as the Constitution. I think we went through that earlier, including the Interception Act. There's some act with a long name that I can't deal with it now. But Interception and Removal of whatever act. Let's just call it intelligence legislation. Do you accept that?
Yes, Chair.
Thank you. Right. Now, I'm just going to put a proposition to you again to avoid any toing and froing. There's a letter which is an attachment to all these cases, and it's well known. I'm sure you have come across it as well. Yeah, which was written by Minister Gordhan to Minister Trevor Manuel on the 22nd of February 2007. That would be around the time of the establishment of the unit. You know what I'm talking about?
Yes, Chair.
Yes.
This is where the funds are requested.
Absolutely, yes. Yes, that's the one, yeah. We'll try and put it and identify and put it up, Chair, but it's already in the system. I'm just trying to save time here. Okay, I would have gone through this letter in detail, but let me just give you what my conclusions are around it, and you can confirm or dispute. This letter, in essence, says this, and I'm paraphrasing, so don't hold me to it with a gun on my head. It says, Dear Minister Manuel, we in SARS require capability to do intelligence work.
The terms are infiltrate and penetrate, Chair.
Infiltrate and penetrate, yeah, well, yes. Yeah, but on the understanding that that constitutes intelligence work, and therefore, and that work is outside of the mandate of SARS, and therefore...
Yes, the infiltration and penetration is indeed outside.
Thank you, yes, indeed. And therefore, we would like to have money allocated to NIA, that's the National Intelligence Agency, so that a unit housed at NIA can then be used to satisfy our needs, because it falls under them in terms of legislation. As I say, I'm paraphrasing, but would you agree that that's a gist of what was being proposed?
That was a proposal at the time, yes, Chair. I recall it quite distinctly. What should be read with that document is the draft operational agreement on the NIA side and then the legal opinions on the NIA side, the National Intelligence Agency side.
Yes.
In respect of that concept that letter sought to create.
That's fine. That what you are referring to now is
Just hold on to that, Mpofu.
Sorry, Advocate Mpofu, I don't want
No
to
problem.
interrupt you, but I don't have that letter you're referring to.
Bundle A, page 4370. Okay, I'll send it to you on WhatsApp in the
No,
meantime.
it's fine, it's 4370 of bundle. Then the person can put it up on the,
Okay,
Anim
fine.
can put it up on the screen for the members as well.
Okay, so enough, that will happen. Excuse me, I'm just saying I can send it to you on WhatsApp as well, if that will take time in the meantime. Okay, thank you, Ms. Power. Yeah, the document you are referring to is a document, and again, because of time, I hope we'll not quibble about it because you have, as you say, you are familiar with it. That document is called agreement, or let's call it a draft agreement as you call it, between the National Intelligence Agency and South African Revenue Services for cooperation between NIA and SARS, and is dated 17th September 2002, and it's attached to the letter on this version as PG6, which probably means Pravin Gordhan 6 in one or other litigation here. But that's the document.
It's not that document I'm referring to, Chair.
Not that one. Okay, fine. That's fine. Let's
There's a, if I can try and be brief, there were several memoranda of understanding and operational agreements between the South African Revenue Service and the intelligence agencies and law enforcement agencies over many years.
Yes.
This is one example.
Yes.
This remained in place. I think it still remains in place to this day, unless it's been brought to a close.
Cancelled or whatever. Yeah. No, fine.
Yes.
Okay.
If we can go back to the letter.
Yes. And to the letter, yes. Okay, fine. Let me read it out so to save time. 2.1 of the letter says, collecting tactical intelligence invariably means penetrating and intercepting organized criminal syndicates. This is an activity for which SARS does not presently have capability, including the legislative mandate to manage clandestine activity.
Right.
Yeah. Okay. Now, the point I'm making, for the purposes of this commission, I don't want to get into all that, is that the public protector came to the view that the activities of the unit that had been, that were understood by her to be taking place in respect of those 8 sources that we spoke about earlier, were in contravention not just of the Constitution, but also of the relevant legislation, intelligence legislation, to use the general term. You agree with that?
Yes, Chair.
Thank you. And again, that is that's how she came to the conclusion of so-called rogueness. Okay, thank you. If you agree on that, then it's fine.
Chair, no, Chair.
Yes.
Just a point.
Yes.
In response to the question. This document does not relate to the unit that the Public Protector investigates, Chairperson. This document relates to a series of planning sessions and interactions between the then National Intelligence Agency and the South African Revenue Service in the years 2005 until this letter came about, where it was agreed that there will be a capacity within the National Intelligence Agency dedicated to assist the South African Revenue Service to intercept and infiltrate organized crime syndicates. And that refers to things like use of agents and undercover operatives and that sort of thing. And that the Revenue Service would effectively ensure payment for the first 3 years of the creation of such a capacity within the National Intelligence Agency. So if you look at paragraph 2.4, there were estimated personnel costs for 3 years forecasts. And that was in consultation with the National Intelligence Agency. On the flip side, within the National Intelligence Agency, there will be similar documents speaking to the same thing. But it was never seen through. In other words, this document, for instance, is a document that seeks funding from Treasury to be directed to the National Intelligence Agency. The funding was never released. It was approved, but it never occurred because the funding was never released, the unit was never created, and it died a death.
Yes.
It should not be confused with the Special Projects Unit,
Okay, Mr.
as it was known in that time.
Thank you. Believe me, that long answer is not necessary. I'm really trying to save time here. The only point I'm making, Mr. van Loggerenberg, actually, I think it was Mr. Goddan, one of the people involved in this, their version, to paraphrase, is that NIA lost appetite and it was not carried through, like you are saying. So I'm not there. But that is common cause between you and me. The only, do you understand that?
Yes, Chair.
Yes. So the only thing I'm saying to you is a very simple one, which is that in coming to her conclusions, the public protector, among other things, considered this letter and the fact that it was suggesting, at the time, admittedly, something that would have been in breach of the law. I mean, that should be obvious. The only reason that SARS...
I understand, Chairperson.
Yes, do you
My
agree?
response is, the error is that this letter does not relate to the unit that she expressed findings on.
Okay, I'm going to try again. Mr. van Loggerenberg, the issue is that she might have wrongly relied, the letter might be talking about a soccer game or whatever. I'm not there. I'm saying to you, do you accept that among the material that led the public protector, rightly or wrongly or whatever you think about that, that led the public protector to her conclusions was the fact that in this letter, Mr. Goddan was implicitly, not emphatically or explicitly, was implicitly acknowledging that was being proposed would have been illegal to be done at SARS. Hence, they were asking NIA to cooperate. That's all. That she considered that this letter as part of the material. Do you accept that?
If she did, I accept that, Chair.
Okay, thank you.
Okay. It's 4171. So, Chair, that's bundle A. Bundle A 4171. I know you've accepted it, but just for the record for the committee. In Mr. Goddan's affidavit, Chair, 73.3, he says, in a memorandum dated 2 February 2007, Mr. Pillay and I sought ministerial approval for the establishment of the SARS investigative unit within NIA. Ministerial approval was sought and obtained only because the proposal to establish the SARS investigative unit within the NIA would have required a transfer of funds from SARS to NIA. Yes, that's all really I'm saying. And I will, don't worry about detail. I'll deal with Mr. Pillay as well. So that's why
I accept that, yeah.
You accept that, thank you. And I don't want to mislead you that you accept two things at the same time. You accept my real proposition, which was that the public protector relied inter alia on this letter. If you don't,
know.
Let me ask.
If that is the submission.
Sorry, sir. Sorry, I interrupted you.
No, I don't know, Chair. If that is the submission of the public protector, I have no reason to doubt that.
All right. Well, if you have read the public protector's report, you will know that you don't have to do it now, but in your own time over the weekend, you must go to 4.4.1.18 of the public protector's report. This is the part, Chair, I was looking for earlier. And while I'm at it, okay, no, let me kill one bird for now. That the item there says a copy of a memorandum from SARS to the former Minister of Finance, Mr. Trevor Manuel, dated 7th February 2007. That is this document. That's listed as one of the documents upon which the public protector relied for her conclusion. So that's not something that can be in contention for anyone who has read the report. Agreed?
Agreed, Chair.
Thank you. And Chair, the earlier point I wanted to make about this, I might as well make it now in the form of a proposition summarized for you for custom purpose to try and speed up Mr. Van Loggerenberg. That section of the report is called 4.4.1. And this, let me warn you already why I'm doing this, so that when you answer it, you know where I'm going. One of the conclusions by you and the court, the three judges in this particular matter, is that, and I think you said this yesterday or the other day, actually there was no investigation. This was just all a sham and going through the motions because the decision had already been taken. Am I summarizing it correctly? Predetermined outcome.
No, I've never said that, Chair.
Okay. Do you think that? Maybe you didn't say it.
I have suspicions, but I'm not comfortable in expressing suspicions when I lack facts. I won't do what's been done onto me.
No, that's good enough. I know you've never said it, but I know you think it here. So, all right. So the point I simply want to make now is there's a list, excuse me, of something like, that list goes from 4.4.1.1, I can't read all of them, we'll be here all day. And that includes letters to the president, letters to the Inspector General, letter to the minister, letter to Mr. Mahashula, letter to the South African Security Agency, acting SARS commissioner, and so on. A list of and recordings and so on, and letters to Minister Manuel, notices in terms of 7.9, something like 40 to 50 items. And those are the items that show the journey that the public protector traveled with this matter. And the proposal I want to put to you is that I'm going to argue at the end, and I'm giving you an opportunity to comment, that that alone is an indication of, as I said earlier this morning, the lengths to which she went, and that to suggest that there was actually no investigation, this was just some plaything, is absurd. What do you say to that?
I say that one should reflect on what was put on oath by me before court in respect of the content of the report by the Public Protector. And if only the Public Protector engaged any one of those 33 people that I had mentioned earlier, they would have been able to assist her to not make the errors that were made in the report. That's my response.
Sorry, okay. All right, I missed that response for some reason, but it's fine. I'll read all about it.
Documentary review. If only she had done, which is what I'm complaining about, which is if only she had spoken to the implicated people. Between all of us, we would have been able to clarify for her those errors that she ultimately made. She would not have made those.
Yes, but
it's all contained in the court papers before the court, which were also not disputed by her.
yes. No, that's fine. I don't want us to go there again. I think we're done with that. You accept that she interacted with Mr. Godan, the so-called most prominent person, correct?
Yes, I said she interacted with, of the people I listed, she interacted with at least the first three, being Mr. Godan, Mr. Pillay, and Mr. Magashula.
Yes, and it's common cause that she did not interact with you because she could not find you, or her people could not find you. We accept that, so I don't want to go back to that. Agreed?
All the other 33 people associated with the unit.
Yeah, well, she's the public protector. You know, she's her primary concern is that's why I talked about primary people. For example, there's the act called the Executive Management Ethics Act. It only applies to Mr. Godan. It wouldn't apply to you. That doesn't mean you are less important. It just doesn't apply to you. Do you accept that?
Yes, Chair. I think I've answered your question as best as I could, Chair.
No, that's fine. All right. And I'm saying, Mr. van Loggerenberg, just so that you can have a peaceful weekend. Well, the statement that you make, let's say in the ideal world, she could have spoken to, what did you say, 33 people or whatever? Let's say she could have...
Anyone in the unit, Chair.
Yes.
Anyone in the unit at the time.
Yes. Your point is that if she was able to speak to all those people and was able to reach them, the report...
Those in the know.
No, let's say all of them. Let's make it even worse. Yeah. If she could speak to all of them, then the report would have been qualitatively better. That's what you are saying.
She would not have made the errors that the court found to have been made.
Well,
a simple thing, Jay, like calling Mr. Manike an employee of the unit, and then accepting everything he says of the unit as if he was a member of the unit.
Yes.
This letter that you've just put up is another example. There are many.
Yes. No, that's fine. No, don't worry about that. The courts have said she's human, and I think we believe the court. Like all of us, if she makes a mistake by calling Mr. Manike, whatever you are saying, that's not impeachable conduct. That's not the point I'm making. I'm saying your overall point really is that if she had spoken, and I'm exaggerating for effect, if she had spoken to all the 33 people, the report would have been qualitatively better, which any right-minded person must accept. That's what you're saying.
It would have been without the errors contained in it.
Yes, Mr. van Loggerenberg, if it doesn't have those errors, would it be better or worse?
It would be better.
Thank you. All right. So
Thank you, Advocate Mpofu. Please throw your last...
last point. Okay, fine. I'll leave that topic then. I think, anyway, we've done justice to it. Thank you, Chair. Then, if we can then quickly go to the letter. Can it be put up? I think I gave the page number. Okay, anyway, I'm just going to ask you about it. You may or may not be aware of this. But, and again, I don't want to have a long debate with you. if it looks like we're going to have a long debate, we will raise it with Mr. Pillay, because he would, unlike you, he would have had proper warning of the letter. So, but I just want you to, is it up? Oh, okay, it's not on. This is a letter written on the 18th February 2021 to Advocate Mkhwebane from SARS by the current commissioner for SARS, Mr. Kisweta, regarding, just for your assistance, regarding the question of the equipment. Are you aware? Oh, there you are. Are you aware of this letter? Just run it to the end, just to show the date. Can you see it, Mr. van Loggerenberg?
Yes, Chair, I can see it.
Thank you.
No, I've never seen it before.
You are not aware. Okay, good. Okay, in that case, I'll just give you, I'll ask you to just comment on one thing, and I'll say I'll converse it with Mr. Pillay. Paragraph, okay, let me quickly read it, Chair. Dear Advocate Mkhwebane, it says, Advocate Mkhwebane, the Public Protector. There's even a debate about that. Okay, it's number one. I trust you are well and that you have started 2021 on a positive note, on a positive and constructive note. One. Two, and this is the paragraph I want you to comment on. I wish to inform you that SARS will be vacating its premises at River Walk Office Park on 31st May 2021. You may recall that the equipment that formed part of the Public Protector's investigation into the alleged so-called rogue unit was securely stored in the basement of the said premises under supervision of the DPCI and the SSA. SARS will be relocating that equipment to a new secure location under the supervision of the South African Police Service and the SSA at a date to be determined. 3, you are most welcome to send representatives to oversee the relocation should you decide to do so. It would be appreciated if my office could be alerted to make the necessary arrangements. If you don't hear from you, to the contrary, from the office prior to 15 May 2021 in this regard, SARS will proceed with the relocation. Kind regards. Very nice letter indeed. But
yes, Chair.
Yes, but for the purposes of our interaction, I just want to alert you to two things. One is that there was some equipment which was, there were clearly some equipment that belonged to the so-called rogue unit, which was securely stored at the basement of some building, and that.
No, I disagree. Yeah.
Okay, well, okay. Let me read it again. You may recall that the equipment that formed part of the Public Protector's investigation, excuse me, into the alleged so-called rogue unit was securely stored in the basement of the said premises under the supervision of DPSA and SSA. Is Mr. Kisweta lying here?
No, Chair, he's referring to the equipment that is contained in the photographs in the Rule 53 record of the review application, and that equipment's got nothing to do with the unit that was investigated. In fact, it's the equipment that is listed in
the Kpmg report.
No, in paragraph 198 of the judgment, the 3 sets of equipment.
Yes. Mr. van Loggerenberg, please, you're going to make a war between me and the chairperson. I'm saying, let's say I accept everything you're saying, but I'm saying that you cannot say that except for the part where you say that it has nothing to do with the unit. Because that can only be true if Mr. Kisweta is making it up. He says, you may recall that the equipment that formed part of the Public Protector's investigation into the alleged so-called rogue unit was securely stored in the basement of the said premises under supervision of DPS. Whether that was a teaspoon or a surveillance, whatever, I don't care.
Yeah, I understand exactly. I think Mr. Mpofu is not understanding me. I accept that equipment was kept in secure storage in the basement at Riverwalk offices under the supervision of the DPCI and the State Security Agency. I accept that.
Yes.
It dates back to February
That's fine.
2015.
All right, thank you.
What I don't accept is the second part of what Mr. Mpofu is putting to me, Chairperson, which is that this is the equipment that belonged to the rogue unit. It did not. None of the people in the high-risk investigation unit ever seen that equipment in their entire life, let alone use it.
Yes, but then that's not a criticism of Mr. Mpofu, that's what I'm saying. Then that's a criticism of Mr. Kisweta, because it's he who says this in the letter.
No, I read it completely different, but I don't think it's
Fair
going
enough.
to advance
Yeah,
anything. I read
That part
read it
is
as-
fair enough.
Thank
Okay.
you, thank
Okay.
you. Thank
No,
you,
no,
Mr.
I'm
Van-
sorry,
Van
Mr.
Loggerenberg.
Sorry, Chair, I'd like to hear what Mr. van Loggerenberg has to say here. I'd
Yeah.
like to hear his complete answer, if I may.
Why do you disturb the chair?
Seriously.
Sorry, Chair, because Advocate Mpofu was not letting Mr. van Loggerenberg finish his answer.
Oh, Chairperson.
I'd really like to hear.
Now, please stop. I was on the platform as a chairperson, and you don't know what I was doing. Because when I started this session, I made an announcement. You were not here. Please. I want you to wrap up now, Advocate
Chair,
Mpofu.
Chair.
I've given
I know.
15 minutes and beyond that.
Chair.
Thank you.
You know that you can see that I'm trying
Yes, please.
to assist you. But Chair, I do need your protection. I cannot be abused like this.
I've already
Thank you.
attended to that.
Okay, right, all right. So, yes, sorry, Mr. van Loggerenberg, if I was not interrupting you to be rude. I'm simply trying to move with the ruling of the chair that we must try and give the members an opportunity. I've jumped a whole lot of things here. And I'm at the same time trying to avoid having to recall you, Mr. van Loggerenberg. So I'm really trying to assist the process. I've now lost my train of thought here. I was saying, Mr. van Loggerenberg, I'm making a simple proposition, and to be fair, you've answered it, that you read it differently. That then will be a matter for argument. But for the record, the only point I was making to you is that it is not me, because you're saying you disagree with Mr. Mpofu. I'm reading to you, it's signed not Mr. Mpofu here, it's signed Edward Kisweta. And it is he who says, who described it as the equipment that formed part of the Public Protector's investigation into the alleged so-called rogue unit. Not me, as long as we're clear on that.
Yes, it's the very same equipment listed in report 36 of 2019-20.
All right, I give up.
Thank you, Advocate Mpofu. I think that's where we're stopping.
Chair,
thank
well, I reserve my right then, Chair, to recall the witness if we have to come to that.
Thank
Again,
you.
as I say, just for your comfort, Chair, I will do my best, if there are topics that I haven't covered, to cover them with Mr. Pillay, because they basically deal with the same thing, so that we avoid having to call Mr. van Loggerenberg. But I'm reserving my right. Thank you.
Thank you, Advocate Mpofu. Mr. van Loggerenberg, before we finish with you at 3, I am now going to invite and recognize the honorable members of the committee to interact briefly with you. So be ready for that. May I start at the virtual. It will be Honorable Zungula, followed by Dlagude and Mananiso. Any hands here? Honorable Maneli. Heron. Sukas. Milam. Van Minen. Gondwe. Nodada. Mkhwebane. In that order. Honorable Zungula.
Thank you, Chairperson. Afternoon.
And Mautwe. Go ahead, Honorable Zungula.
Okay, afternoon and afternoon to you, Chair, honorable members, and the witness. My first question is, how much was spent in procuring the so-called spying equipment? I think you would know what I'm talking about. Secondly, in the annual performance plan, did you disclose the nature of the equipment, in the sense that was this expenditure openly disclosed to the National Treasury, and the National Treasury knowingly authorized the budget? My third question is, which SARS regulation gave authority for the purchase of the so-called spying equipment? My last question is, are you aware of the engagements between SARS and SSA on surveillance issues? Why did this engagement not result in SSA cooperating with SARS in the manner proposed by SARS? That is all, Chair. Thank you. I'm not sure if the witness has captured all of the questions, because it is 4 straightforward questions.
Okay, just if the honourable member can just repeat the last question for me, please.
Are you aware of the engagement between SARS and SSA on the surveillance issues? Why did this engagement not result in SSA cooperating with SARS in the manner proposed by SARS?
Thank you, Honorable
To clarify the last question, is this in relation to back in 2007, Honourable Member?
Yes.
Okay. Thank you, Honorable Zungula. Mr. van Loggerenberg, you got that? What, do you want to proceed?
Yes, Chair.
Go ahead.
In my time in the South African Revenue Service, I've never participated in the acquisition of spying equipment for any of the units that I managed. So the answer would be 0 rand. All equipment of any unit that I ever managed or participated in or worked with had to submit, not just during the planning phase, but during the internal audit and Auditor General of South Africa asset audits. We had to account for everything. So every item assigned to a unit or a component or a division or whatever had to be barcoded and reflected on an asset register. I don't know which SARS regulation, because I've never had to make an application of that kind. Yes, I am aware of the engagements between SARS, and it was then not yet known as the State Security Agency yet, Honourable Member. It wasn't so much on surveillance issues per se, it was more a case of having a dedicated ability within the National Intelligence Agency to assist the South African Revenue Service at that point in time in dealing with the illicit economy in ways in which the South African Revenue Service was not able to. There was a change of guard around the same time. And so at least, well, there were still hopes that it would eventually happen, and I still believe it ought to. But for some reason, I think ministers changed and director generals changed and so forth. and the entire matter just came to naught. Thank you, Honourable Member, and thank you, Chairperson.
Thank you. Thank you, Honorable Zungula. Honorable Lagude.
Thank you very much, Honorable Chairperson. Good afternoon to you, the Public Protector and her team, and also our witness, Mr. Loggerenberg. Honorable Chairperson, oh my God. My apologies. Let me switch off my video so that I can be audible. Honorable Chairperson, I want to ask our witness, Mr. Loggerenberg, on his affidavit, paragraph 5, he was requested by the evidence leader who Advocate Bauer to elaborate further on what he said on paragraph 5. And while he was doing so, he indicated that from 2009 to 2014, the so-called rogue unit was under attack. There was bullying and firing of people. My question there is, who was doing that? Was it internal people, their bosses, or was it from outside? If you can respond to that. And also yesterday, while he was being questioned, he also mentioned that he was responsible for five units, including the so-called rogue unit. Were all those, the other 4 units, subjected to the same treatment as the so-called rogue unit? If not, what could be the reasons for that? Then, Honorable Chairperson, there is a continuous mentioning of the IGI report. So, and also the name of the former IGI, Dr. Dintwe, keeps on popping up. So I want to understand if the report that is being referred to as the IGI report was then a report that was compiled by the former IGI, Dr. Dintwe. And also, on the court application by Mr. Loggerenberg and others, I want to know from him if the IGI did oppose that application in court. If not, what could be the reasons for that? And coupled with that, Honorable Chair, I want to know if the IGI did investigate, as per the Skakane report, that was in that report of Skakane. Thank you very much, Honorable Chair, for the opportunity.
Thank you. Did you get all of those questions, Mr. van Loggerenberg?
I think so. Thank you, Chairperson. Thank you, Honourable Member.
Please go ahead.
Honourable Member, with respect to my paragraph 5, I did not say that the unit came under attack. I said that the portion of the Revenue Service responsible for law enforcement came under attack, and increasingly under attack from those years. Where those attacks came from were from multiple quarters. They came predominantly from those persons or individuals or companies, people associated with the companies or business entities that were under investigation by in prosecution or under order by the respective components within the law enforcement division within the Revenue Service initially. And then I also listed in some instances, as these attacks increased, it began to include certain individuals within law enforcement, the state intelligence agencies, organized crime gangs, and so on. And in some instances, those relationships were, symbiotic. And then ultimately, some of the attacks were also then advanced by some people who had left the institution and their friends who remained within the institution. The four other units that I managed, Honourable Member, I described them in quite some detail in my affidavits before that I submitted to the Commission. None were treated in the same fashion as this particular small little unit. And I honestly cannot tell you why I think that's the case. I would have to speculate. But I do think it has something to do with some of the 81 investigations that they were that they had done and were still busy with around that period. The Inspector General report that that was discussed during evidence was in fact signed off under the Inspector General that preceded Dr. Dintwe, which was Ms. Faith Khadebe, the late Ms. Faith Khadebe, ambassador, and not Dr. Dintwe. In my application to review and set aside that report, as indicated in the annexure that I think was provided to the committee under case number 91160 of 2019, both the Inspector General and the Minister of State Security initially opposed my application by filing notices of intention to oppose. They then failed to provide the Rule 53 record, even after I'd given them additional time to do so. And then I filed my final affidavit and wanted to place the matter on the court roll. And it's at that point then that their attorney contacted mine, and what resulted from that was the consent order as provided to the committee. Did the Inspector General investigate what was in the Sikakane report? Well, I don't know actually, Honourable Member and Chairperson, because I've never seen the Rule 53 record of that process. All I can say is that the Inspector General of Intelligence report of 2014 was concluded prior to the conclusion of the Sikakane report by about 5 days, if I'm not mistaken. The Sikakane report is dated 5 November, whereas the IGI report is dated 31st October of the same year, 2014. Thank you, Chair.
Thank you, Mr. van Loggerenberg. Manani, sir.
Thank you, Chairperson. Let me start by welcoming the witness before us, and as well greet the Public Protector and Advocate Mpofu, and as well the Parliament team. Chair, I would like to start with a comment with regards to the affidavit of Mr. JVL. I hope that indeed he came before us based on what he has indicated on his affidavit on page 1, paragraph 4, and I hope that there are no motives behind. I have only 3 questions for him, and it's based on his affidavit. My first question, Chair, is on page 3, paragraph 7.6. You stated that adverse findings were made against the advocate Mkhwebane in her capacity as PP. Please name one or perhaps two. Number 2, paragraph 4, page 4 actually, paragraph 7.11. You indicated to the House that you were, you actually, you are a whistleblower. So I want to check what would have motivated you to be the whistleblower in this particular moment. Lastly, Chair, my last question is on page 5 to 8 with reference to paragraph 7.12.4. How would you classify your working relationship with the PP? Because from page 5 to 8, you can tell that you don't have a good relationship with the public protector. And further, can you just give us a view in terms of how can you classify her leadership? Thank you, Chairperson.
Thank you, Honorable Mananiso. Mr. van Loggerenberg.
Adverse findings, Honourable Member and Chairperson, would examples would be 48521 of 2019. That's one court judgment that made adverse findings against Ms. Mkhwebane. Another example would be, I'm just taking off from what's been provided, the 36099 of 2019, which is another case number where the court made adverse findings against Ms. Mkhwebane. Yeah, those would be examples, Honourable Member. What motivated me to be a whistleblower, I undertook, when I resigned from the Revenue Service in 2015, to those colleagues of mine who were in a terrible state of trauma, that I will not rest until justice is served and the truth is known about the good work done, because at that point in time they were under absolute public humiliation and siege. That remains my motivation. My primary motivation at a broader level, I set out in paragraph 3 of my affidavit to this committee. I have no relationship with the Public Protector or the Office of the Public Protector whatsoever, and I have no view on the leadership of Ms. Mkhwebane as the Public Protector, because I just simply do not know her and have never interacted with her. Thank you, Chairperson and Honourable Member.
Thank you, Mr. van Loggerenberg. Honourable Heron.
Thanks, Chairperson. Chairperson, I have some questions in terms of Directive 5.9 that I would like to ask the Advocate Mkhwebane. So, shall I do that later and deal with Mr. van Loggerenberg?
Keep that,
okay.
Please.
I would like to just follow. It's really partially covered. My first question to Mr. van Loggerenberg is the role of a whistleblower that he claims from August 2016. When you approached the Public Protector, Mr. van Loggerenberg, in 2016, were you lodging a complaint as is contemplated in terms of the Public Protector Act, asking her, the incumbent at the time in any event, to investigate a specific complaint that you had, and what was the nature of that complaint? I don't really understand what a whistleblower is who goes to the Public Protector, from my understanding and from the legislation and my own use of the Public Protector's Office, you start a complaint by lodging, you start the process by lodging a complaint. So did you in fact lodge a complaint that you wanted investigated by the Public Protector, and what was it?
Thank you, Honourable
No,
Member.
he's not done, Mr. van Loggerenberg.
Sorry, I've got to
See,
find my questions.
He's got some nice pauses. Please allow him to continue. Continue, Mr. Honourable Heron.
I'm just trying to find...
It's been 3 days, I can
Yes.
understand, in terms of the notes.
I just wanted to go back to the evidence around lawful surveillance, because Mr. van Loggerenberg spoke about the unit conducting lawful surveillance, which involved sometimes staking out robberies and acting when those robberies related to tax matters. I'm not sure what I understand. Maybe you can explain what lawful surveillance is, but also where would the unit have gotten the information as to what robbery was going to take place in what place? I don't understand that evidence and what the unit was actually doing in terms of lawful surveillance. I think I am almost done, Chairperson.
It's okay, take your time.
I've lost, there is a question. Oh, yeah, my final question, Mr. van Loggerenberg, is in the affidavit and in the attachment you write, and it relates to the YouTube video in the main, your attorneys at the time, Weber Wenzel, write to the Public Protector requesting an apology or demanding an apology and threatening to pursue action if an apology and a withdrawal of some of the rogue unit comments is not made, threatening to sue for defamation. And I'm wondering if you pursued that, because Senego attorneys wrote back and said that they would not be issuing an apology. So did you pursue litigation against the Public Protector for defamation? And if not, why not? Thank you, Chair.
Thank you, Ms. Honourable Heron. Mr. van Loggerenberg, you got those questions? Please proceed.
Yes, thank you. Thank you, Chairperson and Honourable Member. Honourable Member, I did not lodge a complaint in the manner in which you described in 2016 with the Public Protector. I approached the Public Protector because I was by that time aware that the Public Protector was busy conducting an investigation into state capture. And what I had hoped to do was to provide the Office of the Public Protector with additional information that I had personal knowledge of in relation to the South African Revenue Service and related events, which I had hoped would be taken up into that state capture investigation. Lawful surveillance, well, I gave an example of one of the state warehouses. Now, the Revenue Service oversees multiple warehouses in which detained goods or seized goods or forfeited goods, often of very high value, are kept all over the country. It's part of their statutory duty. The example I gave you is but one investigation that they worked on. In that particular case, they worked closely with the South African Police Service. So it wasn't the unit per se that responded to the robbery. The police official did. What happened in that particular case, in a broad sense, because I'm wary of my oath of secrecy, is that somebody gave information to the South African Revenue Service via the suspicious activity report system that existed at the time. That information led to the identification of someone who was able to provide additional information. And then the purpose was really just to go and place the people around the state warehouse for that period in the event that the information that was provided proved to be true. It did prove to be true, and in that case then the police came and if I remember correctly, 6 people were arrested ultimately, and they were trying to break into the premises and steal high-value goods. I can just also say that there is a legal opinion that was provided to the Revenue Service in that respect that I can make available should you be interested in that. But that's the kind of surveillance that that I was referring to. On the YouTube matter, indeed, I did want to pursue the legal matter against the Public Protector's Office. But events overtook the situation for me, because shortly thereafter the report came out, and yeah, then I was besieged with the report. At the time, the attorneys acted pro bono for me, and the understanding was that if I really wanted to pursue the matter, I would have to put up some funding. And there were questions around how exactly I should go about doing so. I just simply didn't have the resources or time, and I was also besieged with other events in my personal life. Thank you, Chair and Honourable Members.
Thank you. Thank you, Honourable Heron. Honourable Sukas.
Thank you, Chair. I want to start by thanking Mr. van Loggerenberg for his courage to appear before the committee and to put his testimony before us, especially in light of your physical discomfort. I also, on the record, want to apologize to you because I was greatly disturbed by the fact that I believe we crossed the line by you having to explain your medical condition here to us and to the rest of South Africa listening in. And I want to commend you for the courage that you have to address, to speak on your medical condition, and also to speak on behalf of other people that are similarly afflicted. I want to ask you only 3 questions, and the first is if you could describe to the committee the work of the high-risk unit and why it was referred to as the high-risk unit. What was the risks? In your view, what was the value of this unit to SARS? And I note that you said that as a manager you have expressed concern for the impact on the staff of the high-risk unit. Could you reflect to this committee on the personal cost to yourself and to your staff, and what it has cost you personally, financially, and the impact on your career and the rest of your team since this investigation into you and the unit, from the start of the investigation up until today? Thank you.
Thank you. Please respond, Mr. van Loggerenberg.
Thank you, Chairperson and Honourable Member. Thank you for your kind words. To describe a unit, in effect, it was intended to conduct those parts of the investigations and financial investigations and criminal investigations and audits that we were conducting, focusing on sectors within the illicit economy in our country, where ordinary auditors and investigators felt very uncomfortable in working because of the threat to life and limb, and also just fear. I recall, for instance, how the unions wanted us to begin to pay everybody danger pay and buy them bulletproof vests and bulletproof vehicles and so forth at the time, which would have been just simply not affordable. And at the same time, the demand on the South African Revenue Service to assist other law enforcement agencies and intelligence agencies to address crime and organized crime increased tremendously. And so we were caught in a situation where, people planned to bomb my office, for instance, to get rid of evidence. I recall around that time how one of our investigators was shot at in his driveway, how another investigator was murdered in his driveway, killed. The fact is that as the Revenue Service over the years became more effective in addressing these hardcore organized crime types, it was not easy for them anymore to just bribe their way through or threaten their way through or so on. It escalated and the risk increased significantly. So that the benefit is obvious in that it enabled us to use a small, more precise investigative capacity to do certain things that were considered to be risky. But at the same time, it also enabled us to apply what we, from a strategy perspective, called the width, depth, and leverage strategy, which was to dedicate resources to focus on certain matters, regardless of the time it might take or regardless of the challenges that we took. And then lastly, it was a support unit that also assisted the law enforcement agencies and intelligence agencies upon their request once it was approved. Well, the value to SARS, I think one should just reflect on sort of figures. If you take into account, you're talking about a unit that comprised of 26 people in year one. By the end of year two, they were down to 7, and for the remainder of the period, there were 6 people, 6 human beings only at the Revenue Service. That led to, for example, probably the biggest the seizure of illicit tobacco in the history of all customs and tax authorities in the world to this day. One single seizure. The way in which they worked was that they were effectively, firstly I should say they worked very much like most people worked during lockdown. And in a sense, how we are now communicating. They had hot desks initially, and they weren't necessarily required to come into the office every single day and sit there in the office. They were what was coined field workers. And the tasks that they were given were divided into 3 categories of investigations. One was to focus on sectors within the illicit economy that were identified in the strategy as high risk. Examples would be illicit drugs, abalone, CITES products, clothing, textiles, and so forth. And those investigations were categorized as type A investigations, and there it was more giving us a sense of how big is this problem and where are the bad guys. A type B investigation or project was subject specific, so that was where they were investigating a specific person. In fact, in the court papers, I make reference to a mafia boss who's since been convicted and he's serving serving time in prison. And type C project was just a quick something to help someone do something very quickly. And that was pretty much the way in which they functioned, and they functioned as a support unit for the 4 other units that I managed, which were the bigger, more equipped and more sophisticated investigative units. The impact on the staff and the cost, Chairperson and Honourable Member, I really don't have words to tell you. You know, to get a message and a phone call at midnight that a spouse has attempted to commit suicide, and the other spouse, first words to me is, I don't know whether I should contact the employer because I don't trust them. Or to walk into a household where loving two parents are at each other with a small child sitting in the room in the corner crying because of a newspaper article that the unit ran a brothel, and trying to make peace in that household and being confronted with the reality that why would a big newspaper say so if it wasn't true, and why would the Revenue Service keep quiet if it wasn't true? To situations where families split up completely, and the effects on those children in those families and friends. Monetary costs, I can't even begin to give you a sense. There are direct costs, of course, because it comes with legal costs and so on. But I mean, even these 3 days have cost me money. Everybody else, I imagine, who's participating in this process, are getting paid to do what you do. I'm not. I'm sitting here at own cost, and I have responsibilities, which is why I need to leave at 3. So I can just tell you, it would be worth the while to have a look at cost of these things, perhaps in a broader sense, and not to say in this type of committee. What are the costs of people that have suffered as a result of state capture? Not just the whistleblowers, but also other individuals and their families, because the families and the children are the unheard, unknown, unthought of people. Thank you, Chairperson and Honourable Member.
Thank you, Mr. van Loggerenberg. I just want to come back to you because you've just mentioned the point. I know that you've got time limits. I just have a few. Can I squeeze the few hands brief quickly? Thank you for your understanding. Mr. Mike Milham.
Thank you, Chairperson. I also, similar to Honourable Heron, have a few questions for Advocate Mkhwebane, which I will hold over to later. But Chairperson, with your indulgence, there's one simple clarity, a yes/no, that will guide me in my next question. Can I ask that question of Advocate Mpofu and Advocate Mkhwebane?
No, because of the time of.
No, it's just a simple yes/no. It's very quick, because it'll guide my question.
It might not be a yes or no, please, because he's just given us to squeeze a few hands.
No, I understand that, Chair. All right, Chair. My questions then are as follows. Mr. van Loggerenberg, are you aware of the Nugent Commission report, and what were its findings with regard to the various issues raised by the Public Protector in her report? As a follow-on to that, when was it issued, and were the findings taken into account by the Public Protector? Then my next question is, are any of the reports, and here I refer to Sekakwane, KPMG, the OIGI, or the press statement of the Kruin panel, of any evidentiary value in determining the legality or otherwise of the SARS unit under investigation? And following on to that, have any of those documents been allowed to stand unchallenged or without being discredited, disavowed, or set aside? My last question sort of follows on to what Honourable Sukas asked, and that's, are you aware of any deaths or poisoning caused by the operations of your SARS units? And more specifically, are you aware of any form of physical harm caused to any person by your units or their members or their actions? Thank you, Chairperson.
Thank you, Mr. van Loggerenberg.
Chairperson and Honourable Member. Yes, I'm aware of the Nugent Commission report. In fact, there were 2 reports. If I'm not mistaken, they dated December 2018 and January 2019. I might be off by a month. Yes, as far as I know, the Nugent report was put up to the Public Protector in respect of what was stated about the unit. But I think the Public Protector did not necessarily attach too much value to it, if at all. Effectively, from what my reading of the Commission report is that Judge Nugent, that chaired that commission, attempted to contact Mr. Sikakane with a view to understand why he made that finding that the unit was unlawfully established and what was his rationale, but the effort came to naught for whatever reason. It's not all that clear in the report. It seems there was correspondence, but no meaningful response. The Sikakane report and the Kpmg report and the Kanyane report and the Kroon press statement and the IGI report have no evidentiary value whatsoever for various reasons. The Sikakane report, because of its status, it merely says, here are allegations, please investigate. Nobody testified on oath there except me. I was the only person to submit evidence on oath, which was not reflected in that report whatsoever. KPMG has a report, has a massive disclaimer, specifically prohibiting the document from being used as evidence. Well, I mean, aside from the fact that the Kroon statement was recanted, I think it's the end of that, because there was no investigation done. It's not evidence in the true sense. And then lastly, the Inspector General of Intelligence report is as if it never has existed. It's void ab initio. Am I aware of any deaths or physical harm or anything like that caused by people that I managed in my time at the South African Revenue Service? In a general sense, absolutely no. I made reference to one instance of the person with possession of illegal firearms and ammunition and rhino poaching, but it wasn't in the context of his work. This happened when he was on leave, and in that case I dealt with it. And a disciplinary was held, and he took the matter to the CCMA, and ultimately he was dismissed. The docket disappeared with the police, and ultimately he was never prosecuted. But that's not something I had any control over. Thank you, Chairperson and Honourable Member.
Thank you, Van Minen.
Thank you very much, Honourable Chairperson. Mr. van Loggerenberg, I've really just got two questions, and I want to get back to the golden thread that really runs through your affidavit and the crux of why we are actually here. Am I correct in understanding that once the report came out, you were very surprised to find that despite your whistleblowing in 2016 and the emails that you sent, the information that you provided, in fact, none of that information was used in the subsequent report, and nobody from the unit had in fact been interviewed in pursuance of that report? Am I correct in understanding that?
Thank you, Chairperson and Honourable Member. Correct. Yes.
Okay, and then, stemming from that, and also stemming from the Honourable Sukas's question, have you been surprised by how this has subsequently turned out, by essentially what appears to be some kind of lawfare that's really been waged? Have you been surprised by the sort of ongoing campaign?
No, Chairperson and Honourable Member.
Thank you very much.
Thank you. Ms. Gondwe.
Thank you very much, Chairperson. Mr. van Loggerenberg, I'm going to ask you questions pertaining to your
Just try
affidavit.
and raise your voice or come closer to the mic,
Okay.
because I'm struggling to hear you.
Are you? Oh, my apologies. Mr. van Loggerenberg, can you hear me?
Yes, Madam. Yes, Honourable Member.
All right. I'm going to ask you questions, just questions of clarity pertaining to your affidavit as well as your oral evidence before the committee. In paragraph 7.7 of your affidavit, you state that the unit was known as the Special Projects Unit, the National Research Group, and the High Risk Investigations Unit. And my question is, why did the unit have a number of names over the 7 years of its existence? Is it because its purpose or functions were morphing or changing over time? And why, in your opinion, was the unit eventually disbanded in 2014? And I get the impression that it was gradually disbanded because it started with a staff complement of 26, according to you, and then by the time it was disbanded in 2014, it only had, 6 members. And I wanted to find out what became of those, members that used to be part of that unit. And then you also stated in your oral evidence that the unit was consistently under attack as a result of the nature of its work, the work that it was doing. And my question would be, please elaborate on this. And if you could maybe tie it into the 88 investigations that you mentioned during the course of your oral evidence that the unit conducted. Were they investigating like high-profile people, etc.? I just want a bit more detail around why it could possibly have been, you said consistently under attack. I think those were your exact words. And then you also stated in the oral evidence before the committee that during the course of the court proceedings, it became apparent to you, or it emerged that Advocate Mkhwebane had in her possession a classified version of the report of the Inspector General of Intelligence and not the redacted version of the report. And I just want to get clarity on, because I heard you mentioning that the only way she could have had possession of this report was that it had been illegally obtained. In other words, the DG of the SSA could have been the only one who declassified the report. So I want to understand that whether you were surprised that she indeed had possession of this classified report, when in actual fact it hadn't been declassified by the DG or by the minister. And then my question becomes, why do you think she went through the trouble of having the meeting with Dr. Dintwe and the legal advisor of the Office of the Inspector General of Intelligence at the time? I'm not entirely sure if she's still the legal advisor. That's Advocate J. Govender. If she was in possession of this classified version of the report and not the redacted version. And then you state in paragraph 7.8 of your affidavit that prior to the publication of the report in 2019, Advocate Mkhwebane referred to the unit as a rogue unit. And I just want you to just please, elaborate on why you think this was the case. Why do you think she held this view that the unit was rogue prior to the release of the report in 2019? In other words, why was it a fait accompli for her, even though she hadn't released the report? Well, the rogue nature of the unit, that is. And then my last question is,
okay, I was
with
just
respect
about to come in. Please.
You made reference to a fake intelligence dossier, namely Project Snowman, in your oral evidence. And you stated that the dossier was compiled by a SARS official who was dismissed for rhino poaching and the illicit possession of firearms. You also made reference to Project Broken Arrow. Can you just take us in your confidence around the relationship between the two projects, Project Snowman and Broken Arrow? Thank you so much.
It's almost a thesis of questions. Honorable Mr. Johann van Loggerenberg,
I'm pushing now.
Yeah, okay.
Okay, let me give it a go. Because I want to be respectful to the process and the question.
Yeah.
Honourable Member, why did the unit change names? Well, the short answer is really that SARS was undergoing tremendous modernization. And so the unit actually refined its mandate. In fact, the mandate documents are in the court papers. They will tell you what the unit was mandated to do within the legal and policy framework of the South African Revenue Service. And as it refined, we realized we were moving away from something that we thought was special to something that was more akin to research, and then ultimately high risk. So it was just an ordinary thing, and there was no particular reason for that per se. It was disbanded for reasons unknown to me. It was disbanded on instruction of Mr. Tom Moyane, who was the Commissioner of the Revenue Service at the time. What happened to its members? Some of them remain in the employ of the Revenue Service, and they, by all accounts, appear to be productive state civil servants. But the bulk of them have left the institution. I know a lot of them, many of them, especially those with good skills, are actually no longer living in South Africa. They're now living in other countries, and some of them are actually working for other governments in doing pretty much what they were doing for the South African Revenue Service, but I believe some of them are making good money. And I doubt we'll be able to see those kind of skills come back to the Revenue Service at the cost at which we had them. It wasn't just the unit that came under attack. As I said earlier, it was actually the division. The unit came under attack specifically from around 12 October 2014 onwards, and then it became like the label to hang everything, the whole propaganda onto, and that's where this term rogue comes from. I'm a little bit limited in respect of absolute detail in respect of the investigations that the unit conducted, the 81, not 88, Honourable Member and Chairperson. But I can tell you, I mean, to the extent that it's public knowledge, we were, for instance, looking at those 180 plus, some of them, of the 180 plus people from the State Security Agency and their front companies that you would have heard about yesterday in that recording between the Inspector General and the Public Protector, as one example. And so some of them were our enemies, certainly, and they knew we were closing on them. We were also conducting investigations that were beginning to affect very influential people and politically connected people and politically exposed people and so forth. But also very powerful and rich organized crime figures and groupings within the country. There was I think so was a combination of that. Indeed, it seems now to me that what I've learned today is that, as a fact, Ms. Mkhwebane was indeed in possession of the classified Inspector General of Intelligence report from at least 31 January 2019, illegally so, unlawfully so. Why did she try to have it declassified or whatever the case might be? I wouldn't want to speak for Ms. Mkhwebane. I think it would be unfair to her. It's perhaps this entire question is a question to be posed to her. I cannot read her mind, and I wouldn't want to. The connection between Broken Arrow and Snowman is really that Project Broken Arrow appears to have been a sort of a session between people who had beefs with some people within the Revenue Service, like Mr. Gordon or Mr. Pillay and myself, or the institution itself. And they came together and met at coffee shops and had safe houses and phones that weren't registered in their names and laptops and so forth, that was being provided by people who were being investigated by the Revenue Service. And they then had all these different meetings and began to recruit people in order to compile what I think they called a file, which was intended to be given to the then state president with a view to then cause havoc and create chaos at the South African Revenue Service. So that they called Project Broken Arrow. And we know this because some of those people turned against their friends and came and reported that these things were going on. And each time they were asked, put it in writing, put it in writing. So a number of them reported these things, and those documents date to that time. But subsequently, what came out of this, that file that Project Broken Arrow intended to create, was then the document known as Operation or Project Snowman. And it was first leaked to the media in 2009, and then early in 2010, it began to reach other parts and other people with a view to try and popularize this document. I hope I've answered all the questions. Thank you.
Thank you.
Oh, the road unit question. Why Ms. Mkhwebane referred to the unit as a road unit before concluding the investigation? Well, I can conclude in no other way other than that she had already made up her mind at that point that the unit had been rogue for one reason or another. But again, that's perhaps better that question be posed to Ms. Mkhwebane.
Thank you, Mr.
Chairperson and Honourable Member. I'm really at the tight end, Chairperson.
You'll just tell me when.
I have two people.
You'll tell me when you have to leave. Thank you, Mr. Nodada.
Good afternoon to everybody, and good afternoon, Mr. Loggerenberg. The questions I'm going to pose might, seem rhetorical, but I think it becomes very important for you to answer them directly. Mr. Loggerenberg, your core complaint or your core submission or affidavit to us is around you wanting this committee to consider that the Public Protector or Ms. Mkhwebane failed to investigate without prejudice, bias, and was not being fair in giving you a hearing, and there were quite a few errors in that particular investigation, which ultimately made recommendations or what we call remedial actions that have implicated you. So the question I want to ask is, what are these errors that you indicate represent prejudice, bias, and not providing you a fair hearing in coming to the conclusions that you did make? Sounds very rhetorical and seems that it's answered, but I think it's important for you to give context to that, because you go as far as saying that for you it's not the merits of which you are being questioned about, but rather the process that came to the conclusion of what you have been implicated to. The second question is, has there been any court of law or any legal body that has determined what you, through common cause, have agreed with Advocate Mpofu, is the unit that has been called various names? Has there been any lawful institution in the country that you've approached that have determined this unit to be rogue in any form, or has conducted any illegal or unlawful work? And if so be the case, if you can provide details to that. My last question to you is this. There's been an indication that, well, according to the version that has been put by the Public Protector's representative, that you may not been able to be found by investigators, whatever the case may be. So my question to you is this. do you accept that there could be other alternatives that could have traced you as an implicated person in the investigation? And what are those alternatives or avenues that are available that you could have been, that could have been used by the public protector to ensure that you are then provided what you term as a fair hearing or unbiased or unprejudiced opportunity to represent what you have done subsequently in the courts? Thanks.
Thank you. Please proceed, Mr. van Loggerenberg.
Thank you, Chairperson and Honourable Member. Well, what were the errors? I highlighted all the errors in great detail in the affidavits that served before court, and the court succinctly identified them. It would take very long, Honourable Member, for me to list them right now. But they range from issues around the establishment of the unit to issues around how the unit actually functions, to issues around the equipment which is wrongly attributed to this unit in the broad. And that's my point, really, is that I believe had I been heard and had what I said been taken to heart, the report would have been very different to what you see today. Any court or any institution of any kind that's made any determination that the unit was so-called, that label rogue, no. What we sit with is the Kpmg Report, which has been rejected by the South African Revenue Service, the Kpmg Report with all its problems, the Inspector General Report, which is as if it no longer, as if it never existed, and the Kruin Statement. In essence, those are the primary, let's call them some sort of a formal process of some kind. Apart from the IGI one, all the others emanate from within the South African Revenue Service. I couldn't be found, well, I mean, I gave some examples in the affidavit how I think I could have been found. The most obvious would have been to just contact my attorneys with whom the public protector was in contact 3 weeks prior to concluding the investigation. But there are many other ways. I mean, she could have asked Mr. Pillay, she could have asked Mr. Magashula, she could have asked the South African Revenue Service. It was quite widely published that at that point in time I was being charged and appearing before court. She could have asked the police, she could have asked the Hawks, she could have asked the prosecuting authority. She could have made a plea in her YouTube statement issued in June to say, look, hey, Van Loggerenberg, you're somewhere out there, you better come in because I've got some questions for you and I need some information from you. I can think of a myriad of ways in which it could have been done. I would just bore you. I've given you some examples. The bank, for instance, she indicated that she intended to investigate a bank account of mine. Well, the bank has my details. The bank could have called me up because I'm required to comply with my FICA updates periodically. So there are many ways to have gotten hold of me.
Thank you.
Thank you, Chairperson. And
Honourable Maneli.
Thank you, Honourable Chair. Maybe I must also start from the point that the questions to be posed to the witness may look like repetition, but I think there's also an obligation on our side as it relates to the directives under evidence 3.1, 3.2, so that it's also understood that we're asking the questions to establish what we have been asked to establish as it relates to either misconduct or incompetence. So I just thought it's important to do that. Therefore, Chair, it may sound like personal, but I would really want to understand the grievance. And I want to start by saying that when you've had a relief from court.
A what?
A relief from court, I mean from judgments that would have been made, where you feel vindicated, and you still come before the committee and share with the committee. Of course, understanding that we are not another court. So is there a reason, so that I clear my understanding, is the reason about assisting the committee as it relates to that 3.1, 3.2? Because at the end, in the conclusions, I think that's what comes out, is that in your affidavit, is that you have not been given the hearing. You make reference to the point that even the public protector would have gone all out, including incurring costs, to ensure that is heard in the process. So do I have that understanding from yourself that you are not putting a new grievance because you've had relief also from courts? So that's one point. The second point for me, Chair, again, it relates to the same. And I'm raising this cautiously because I had raised earlier that as far as the recording, because I want to get to the recording, as far as the recording is concerned.
I have 5 minutes, sorry to be rude.
5 minutes.
Okay, yes, I'll be done. That's why I'm saying I'm on the recording. I just wanted to put on the recording part that I had raised an issue there of trying to confirm whether indeed I will be referring to the public protector in that recording, which you would have ruled, Chair, that there would be an oath taken. So I'm assuming that there would be no problem in doing that at this point. I just want to check again with regard to the recording. Is the point of the recording about the unlawfulness of the report from the Inspector General of Intelligence, or is it about the ethical standards used by the public protector to get that report, or is it the fact that that report was used as part of getting to findings that the public protector would have made, or all of them are applicable? I submit, Chair. Thank you.
Thank you. Mr. van Loggerenberg.
Thank you, Chair. Chair, the answer to, and Honourable Member, the answer to the first point is really, I responded to an invitation by this committee, which I imagine came from all of the members of this committee. My motivation, I've stated to the extent I'm capable of expressing it in my affidavit. I should just maybe add that I'm hoping that since our public protector, we have nowhere to go if the public protector acts out of the ordinary or improperly or criminal or whatever the case might be, but to Parliament, because that is where the public protector is accountable to. So how do we assume for a moment and accept for a moment hypothetically that what I'm saying is true, that what occurred is indeed criminal and is indeed contrary to the public protector procedures and did affect the rights of individuals and so forth, and these abuses occurred and were perpetrated by the public protector? Assume for a moment that's right. Where do we as South Africans go to ensure that it won't happen again? And so whatever the outcome of this committee may be, I do hope that this is part of our broader constitutional democratic growth because we're really a very young nation. And we're part of the generations that must contribute to the development so that those that come after us live in a better place. And so how do we help build and strengthen these institutions and make sure that they are tamper-proof or shutter-proof or more robust in the way in which they go about doing their business? On the recording, the short answer, Chair, is it's all of what, and honourable member, it's all of what you've said, and of course more, and that we've learned today, which is that effectively the Public Protector used a document in an illegal possession to issue a report and make findings against people that had certain consequences. And now we hear that she's had it, and she never gave that document to anybody at all to respond to or look at or anything like that. So it's all of the items that you've mentioned, in short, Chairperson and Honourable Member. Chairperson, I think there's one more person, unless I'm wrong.
Okay.
I see two names. Chairperson, I really have to go. I'm beyond my limit now.
All right. Must I give you one more person now?
I don't know if I'm past my 5 minutes.
I'm in your hands.
You are aware of what my restraint is.
I'm in your hands. You just tell me now. You can change roles, and you're the ones who.
I need to leave, Chairperson. I really need to leave.
I want to apologize, therefore, to the following three members: Honorable Mkhwebane, Honorable Mautwe, and Honorable Sheikh Imam. Those were the last three hands that wanted to make a contribution. I sincerely want to apologize that we are not getting to you. And therefore, let me take this opportunity to thank you very much, Mr. Johann van Loggerenberg, for the 3 days you spent here. Under the evidence leader, under Advocate Mpofu as a public protector legal team, and fielding in the questions from the members. And we really appreciate your contribution, and we hope that it will assist us in the work that we do. Thank you very much. I don't want to hold you any longer because you have to do now what you have to do. But thank you very much on behalf of this committee.
Yeah, sorry,
Appreciate
sorry,
it.
Chair. Chairperson?
Honorable Mautwe.
Yeah, so what will happen to our questions that we couldn't pose to Mr. Loggerenberg?
Okay, just Advocate Bauer.
Can I make a suggestion that they put it in writing and we ask Mr. Loggerenberg to answer them?
Okay. Did you get that? Perhaps the three members can put those in writing and then they must be responded to by Mr. van Loggerenberg. Thank you. Advocate Mpofu?
Quick one, Chair. Yes, I agree with that. But I just wanted to remind you that we had reserved our rights to recall him. If we elect to exercise it, we'll let you know so that then those questions can be asked. Yeah.
No problem. Thank you. Thank you very much, Mr. Johann van Loggerenberg. You are now excused and released from the commission again. Baie dankie.
Thank you, Chairperson. Just a quick thank you to all the committee members and the legal representatives, including Mr. Mpofu. I understand cross-examination is a robust process. I again apologize if I offended you. And thank you for the evidence leader. And good luck to everybody involved in this process. I know it's something very new to our democracy. And let us remember we only have each other. So let us please look after each other. Thank you.
Thank you, Mr. van Loggerenberg, for the remarks directed at me at least. No hard feelings, and if I offended you, I also apologize to you. Thank you.
Thank you very much. That's where we close it there.
Thank you, Chair.
Thank you. I'm now going to recognize Ms. Fatima Ibrahim. I do immediately, so that we don't waste any time, want to quickly, so that those very brief interactions that members wanted to make or questions, because Honorable Maneli would have wanted to know whether the public protector can confirm this is her voice, and Honorable Heron at the registered, as well as I think the other member, I gone to Kango Nazik, please. So I would want us to, as I indicated, that she can quickly do that, but I think it must be done under oath. And I'm now going to recognize Fatima Ibrahim to help us deal with that.
Good afternoon, Chair, and good afternoon to all the members and persons sitting in the committee and on the platform today. Chairperson, I will now proceed to swear Advocate Mkhwebane in. Good afternoon, Advocate Mkhwebane. Can you hear me clearly?
Please take your mic, Honorable Mkhwebane, Advocate Mkhwebane.
Sorry, what's happening now?
What do you mean, what's happening?
No, I mean that. What's actually happening?
There are members who wanted to ask a few questions from Advocate Mkhwebane yesterday. Okay.
From her directly?
Yes.
No, well, okay. Oh, I see. Is
Yes.
that rule where we can take them down and answer in
Yes.
7 days? Okay.
And therefore I did not want that to happen before she takes an oath.
Well, I can tell you now, Chair, there's no need for you to do that, because we can ask her to take an oath, of course, if you have time. But whatever questions are going to be asked, we will note them and invoke that rule in the directives.
Yeah, but members are going to ask the questions.
No, of course.
And I want that she takes an oath.
Up to you, Chair.
Thank you. Fatima Ibrahim.
Chairperson, I just wanted to clarify that in terms of the directives, as they now stand, the public protector can request that an answer be deferred and that you can make a ruling on whether you agree or not, depending on the nature of the question and whether it can be answered now. This is an oversight process, and members have the right to ask the public protector to answer questions. I just wanted to clarify that, but in any event, I will proceed with the oath. Advocate Mkhwebane, can you please state your full name for the record?
Busisiwe Mkhwebane.
Ma'am, you have been invited, subject to the provisions of Section 16 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act 2004, to appear before this committee and to answer questions in respect of the committee's inquiry into your removal as public protector. Please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a House or committee may not be used against you in any court or place outside Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence required in these proceedings. Please be aware further that in terms of Section 17(2) of the Powers Act, a person who willfully furnishes a House or committee with information or makes a statement before it which is false or misleading commits an offence and is liable to a fine or to imprisonment for a period not exceeding 2 years. You will now be required to take an oath or affirm that the evidence you are about to give is truthful. You may choose to take either the oath or affirmation. Which do you prefer?
I will take an oath as the child of God, yes.
Thank you, ma'am. Can I please ask you to raise your right hand and repeat after me? I swear that the evidence I shall give
I swear that the evidence I shall give
shall be the truth, the whole truth, and nothing but the truth.
Shall be the truth and the whole truth and nothing else.
and nothing but the truth, so help
and
me God.
nothing but the truth, so help me God.
Thank you, Advocate Mkhwebane. You will be sworn in for the duration of these hearings. Chair, we have now sworn in Advocate Mkhwebane. Thank you.
Thank you very much, Ms. Fatima Ibrahim, and thank you to the Public Protector. I had noted Honorable Maneli, Honorable Heron. There are others who are getting provoked. Honorable Mailam, I did note you. Nizothetha nonke nina. Sheikh Imam, quickly in that order. No data. Sukas. Gondwe, okay. Maneli, please.
No, thank you, Chair. As I said, Chair, for further questioning later, I just wanted to be, at least on record, that the Public Protector agrees that that voice is actually her and would have been aware of that. I think it's important so that when you come back to questioning, that could be clarified. That's really that, Chair. Because it affects everything else. We would ask about that report. Thank you.
Thank you very much. Advocate Mkhwebane.
Thank you, Honorable Member and Chairperson. Yes, I can confirm that that meeting took place. Hence, the recording was availed in court. Thank you.
Thank you, Advocate Mkhwebane. Honorable Heron.
Thank you, Chair. Chair, I have about 4 or 5 questions all related to the same thing. Shall I pose them one at a time or 5? How would Advocate
I'll check if what she's comfortable with, all of them, or one.
We can ask all of them and then we will record them.
Okay. Thank you very much. I guess I'm seeking clarity around the possession of the Inspector General report or the intelligence report, the classified document, which I understand it's a criminal offense, and I think you said so in the recording where you said you shouldn't have the report, and it is a criminal offense to have the report. So my first question, and I'm sure, Advocate, you can answer this, even though it's perhaps a little wider than your scope, given that I think you have some intelligence experience as well. I mean, what is an ordinary South African meant to do if they receive anonymously dropped off at their office an intelligence report that is classified? What is the obligation if someone wants to drop a report at my office? I don't think I'm special as a member of Parliament. What is my obligation with regards to that report? And my second question, which is related, is as the Public Protector, what is the obligation to do with that report? Does the Public Protector have an extra duty of care with regards to receiving an anonymous classified report, or does the Public Protector have the same obligation that an ordinary South African has with regards to how you handle receiving a report that you didn't perhaps ask for? The third question is, did the Public Protector do what is required of the law if you receive a report anonymously which is classified and it's now illegally in your possession? Fourthly, is there any reason why the Public Protector could not disclose in Report 36 of 2019-2020 that she had received a report anonymously, that the possession of it was illegal, and this is what she did with it? There appears to be an omission that this report was actually in your possession. And if there was no reason for you not to do that, why is that not in the report? Thank you, Chair.
Thank you, Honorable Heron. Advocate Mkhwebane.
Thank you, Chairperson. With the advice of my legal counsel, we request that we respond in writing. Thank you.
Thank you. That's fair. Honorable Sheikh Imam.
Yeah, thank you very much, Chairperson. Chairperson, before I ask this question, I just wanted some clarity. In the case of Mr. Loggerenberg, now that we're going to send him questions in writing, does he still enjoy the same privileges and protection as if he's appearing before this committee? It's just something for you to think about. Okay, my first question is this, Mr. Mkhwebane. You've heard what Mr. Loggerenberg has been saying time and time again, and that he's never been given an opportunity, no questioning, despite all him requesting it. You've had access to information through 20 different sources, but made absolutely no attempt to even question him. Do you believe that if you had done that, we may not have been here today, which might result in us saving millions of rands of taxpayers? That's the first question that I have. Okay. On the issue of the so-called road unit, I'd rather call it a road unit because my understanding is it might have not been set up lawfully. But at the same time, would you agree with me that while it might not have been set up lawfully, there is no law in the country that says it's unlawful for a structure like SARS to put up this unit if they have reasonable grounds to believe that indeed we have illicit trade, illicit economy, there is great risk to the country. So that's my second question. Would you agree with me then that while it was not lawfully structured, it is not unlawful or illegal for a unit like SARS to put something, if they want to particularly protect the interest of the country? And then lastly, you know, besides not giving an opportunity to listen to Mr. Loggerenberg, who has been implicated, name is in the report, he was at the forefront of this unit. When the whistleblowers came forward and you had access to the report, did you at any time give thought to the fact that indeed there must be something wrong in the country, particularly on the issue of state capture, and that in the interest of the country and the public who has the trust and confidence in the office of the Public Protector, that you need to thoroughly investigate this and ensure that you do justice to your office by protecting the country and people? I'll stop there, Chairperson. Thank you.
Thank you, Honorable Sheikh Imam. Advocate Mkhwebane.
Thank you, Chairperson. Thank you, Honorable Sheikh. Yes, I will also still on this one with the advice, by the advice of my legal team, prefer to respond in writing.
Thank you. Honorable Mike Mylham.
Thank you, Chairperson. Chairperson, before I ask my question, I'd like to draw your attention to Rule or Directive 5.9, which says that a member of the committee, either directly or through the evidence leaders, may ask Advocate Mkhwebane directly to respond to certain questions posed orally or in writing, including factual disputes that may arise, even if she is not at that time giving evidence. Advocate Mkhwebane must respond to such questions immediately, unless she requests a reasonable period of time within which to submit a response. Chairperson, I'm not aware that such a request has been made. She said that she wants to respond in writing, but the directive is that she needs to respond immediately unless she requests a reasonable time frame. We haven't been given a time frame, and we haven't been requested that she be exempted from the requirement to respond immediately. So before I ask any questions, could I get a ruling from you in that regard?
Okay, thank you. I was going to do that at the end, but maybe let me hear her request first. Honorable, Advocate Mkhwebane.
Thank you, Chairperson. Chairperson, I would plead with you and the committee to give me an opportunity to respond in writing, and you can indicate how many days you expect us to respond. Again, to make sure that one is within, and I'm also not, mentioning information which is not possibly true or which is not there. So I would prefer that I respond in writing.
Okay. Thank you. I will impose the time at the end. Honorable Milam.
Okay, thank you, Chairperson.
She has not indicated in terms of the preference on time.
Yeah, Chair, thank you. I'm not clear as to the reason why she is requesting the opportunity to respond in writing. It's not as if she can't answer the questions. I mean, if it was a question that she needs to go and look up, that's a different story.
But Chair, we can't be abused here. You made a ruling.
Sorry,
Why
Chair.
is this member coming back again? You made a ruling, Chair. Can we move?
Okay. Thank you, Honorable Maute. There's a member on the platform. Please conclude.
Thank you, Chairperson. As I was saying, I'm not clear as to why she is not answering simple questions of fact that are in her knowledge. If she needs to go and research something, that's a different story. But if it's a simple question of fact that's in her knowledge, she should be able to answer the question immediately. I just need some clarity in that regard.
Can I rule that you ask your questions?
Okay.
I indicated I will impose the time because I have no reason to doubt the reasoning.
Okay. Advocate Mkhwebane and perhaps, well, yeah, let me ask you this. Simple yes-no question. Are Sianejo attorneys your private attorneys, or are they the attorneys of the institution of the Public Protector? No, I'm waiting for an answer on that.
Okay. Just switch off Advocate Mpofu, Advocate Mkhwebane.
I will defer and answer it in writing.
Chair, with the greatest of respect, I'm sorry, that's a simple yes-no question. Are they your private attorneys or not? It's not something that needs to be written in writing. But okay, if that's the way we're going to play this, it is a clear attempt at delaying tactics, but okay.
No, Chairperson, please.
Mr. Milam.
I mean, honestly.
Please
Chair,
refrain from making such remarks.
Chairperson, I'm entitled within the Powers and Privileges Act to make a statement, express an opinion, and not be held to order by Advocate Mpofu or anyone else. This is my opinion, that we are being subjected to delaying tactics. And I stand on my privileges as a member of Parliament, as a member of this House, to make such a statement. I will continue.
Chairperson?
Okay. Just pause. Advocate Mpofu.
Thank you, Chairperson. Yes, the honourable member is correct. Within the precinct of Parliament, anyone can do anything, even if it amounts to criminal activity, in terms of Section 58 of the Constitution. But that's not why I'm rising, Chairperson. I also have a right to represent my client, if you don't mind. The issue I'm raising is a very simple one. The honourable member must ask the rules within the parameters of the directive. There's nowhere in the directive, which he has just read to you, where it says that Advocate Mkhwebane must give reasons for anything. Whether the question is one sentence or 100 sentences or one alphabetical syllable, it doesn't matter. Thank you.
Honourable Milam.
Chairperson, I'm going to continue with the questions that I had written down here. My first question is, if, as Advocate Mpofu suggests, that the individual, in other words, Advocate Mkhwebane, and the institution are the same, which he made that suggestion on Tuesday, why would Sianejo attorneys respond to correspondence from Mr. van Loggerenberg? And my question was premised on the fact that Sianejo attorneys are her private attorneys and not the attorneys of the institution of the Public Protector, which is why I asked a very simple question and tried to get clarity on that, but I was being frustrated, Chair. Chairperson, I would like to know why the Public Protector did not engage Mr. van Loggerenberg before issuing her report. I know that other people have asked it in a similar question, but I'd like to know why she did not. There was a suggestion from Advocate Mpofu that Mr. van Loggerenberg was not an implicated person in terms of Report 36. Do you agree with that, Advocate Mkhwebane? My follow-up to that is, if a person is implicated, are they not entitled to have their side of the story heard? And again, going back to my previous question, why did you not then do so? As a follow-up, is it not normal practice when you're doing these kinds of investigations and serving legal documents and the like, to serve formal documents on a person's attorneys? In this particular instance, why did you not do so? With regard to the YouTube video that we heard yesterday, in that video, Advocate Mkhwebane, you say you are not targeting anyone. Those are the words that you used. You are not targeting anyone. How do you reconcile that with Advocate Mpofu's questions to Mr. van Loggerenberg that Minister Gordhan was, and I quote, the primary target of the investigation? Then I'd like your opinion on something, please, Advocate Mkhwebane. Is it the suggestion of you and your team that the mere existence of this unit at SARS makes it unlawful? And again, how do you reconcile that with the various court judgments in this regard? Advocate Mpofu made much of the fact that...
I'm
just
sorry
pause,
to interrupt you,
Honourable
Honourable Member. If you can just, this last one, sorry, I just missed something.
I said, the question was, is it the suggestion of Advocate Mkhwebane and her team that the mere existence of this unit at SARS makes it unlawful? And how is that reconciled with the various court judgments in this regard? Then, Advocate Mkhwebane, Advocate Mpofu made much of the fact that out there, South Africans think about a rogue unit. And my question to you is, does it matter what people out there think? Is it not a matter of fact and a matter of law as to whether or not there is such a unit? And further, that those facts have been determined by various courts of the land. Lastly, and this is to follow on to what Honourable Heron asked, with regard to the Inspector General of Intelligence report, what did you do with the copy that you claimed to have found in your reception? Furthermore, how can you rely on a report that came into your possession unlawfully? And lastly, how can you claim to have been impartial or unbiased in your report if you have not afforded the persons that are implicated by that IGI report an opportunity to review it? Thank you, Chairperson.
Thank you, Honourable Mainham. Advocate Mkhwebane.
Thank you, Honourable Chairperson. I would also request that we respond in writing at the after the advice of my attorney, my legal team.
Thank you. Honourable Sukas.
Thank you, Chair. Advocate Mkhwebane, I just have a few questions, and let me also state to you that you certainly have my empathy for having to appear before a committee this size, and it must be hard, and so you really have my empathy with that. I want to ask you, do you believe that you should take responsibility for the omissions of your staff and the actions of your staff? And then Mr. Ibrahim spoke on Monday the need for the public protector to be accessible and that this is an active role. Mr. van Loggerenberg is what I think, and I Googled him yesterday, what we can call a public figure. You also had his lawyer's details. What more should you have done, or your office, to ensure that his rights were upheld and that he was heard, that he had the opportunity to be heard? You stated in public that the special investigation or the high-risk unit was a rogue unit, and indicated that people had died prior to the conclusion of an investigation. When his lawyers asked you not to do this, you stated through your lawyers and said you would not do so and that he should sue you. Given that only very wealthy individuals in this country or members, and that members of the public cannot afford public representation, afford lawyers that would be able to defend them in that way, and that you have the unlimited resources, almost unlimited resources of the state at your disposal, do you think that this was fair and that it granted access to such an individual? Thank you.
Thank you, Honorable Sukas. Advocate Mkhwebane.
Thank you, Chairperson and Honorable Member. I will also prefer to respond on this in writing.
Thank you. Honorable Notada.
Thanks, Chair. I think I've been largely covered by Honorable Milam. But I just want to ask two specific questions to the Advocate Mkhwebane. We just had a witness, Mr. Loggerenberg, in the past 2 days, and his premise of his contribution to this committee is that you failed to conduct the investigation without prejudice. You were biased in the areas in your investigation. Chair, I would like to submit, whether through the evidence leader or through you, Chair, a list of those areas that are alleged that the Public Protector had made in the process, and for her to respond individually to each error, since she will respond in writing in many instances, unless she is able to respond here physically. The second question, Chair, relates to two things. One, there's been a question, there's been two questions posed regarding locating Mr. Loggerenberg. One of them is the assumption that, if you misspelled, a surname, then there might be, a challenge of finding him, one. The second one is to indicate that there may be investigative officers that had been given the responsibility to go find Mr. Loggerenberg. If this is the case, or these were the challenges of not being able to afford Mr. Loggerenberg what he alleges to be a fair hearing, is there proof in this regard that these particular investigators were given the responsibility to go find Mr. Loggerenberg, and they then did so and then reported back that they were unable to find Mr. Loggerenberg, and whether the Public Protector, Ms. Mkhwebane, can indicate what other mechanisms are used in her investigative process to ensure that they locate individuals that may be implicated in what she is investigating as a public protector, to ascertain what mechanisms are actually used to ensure that people are given a fair chance to represent themselves in whatever investigation is taking place. Thank you so much, Chair.
Thank you, Honorable Notada. Advocate Mkhwebane.
Thank you, Chairperson and Honorable Member. Yes, I will still also, with the advice of my legal team, request to respond in writing. But just to clarify, the list of errors, do you know which pages of the engagement, so that we can... I know Mr. van Loggerenberg responded, but did you capture which page or the evidence leader will help us.
He indicated that he's going to share. Is that what you said?
Chair, I'm going to share Mr. Loggerenberg's response was to say that it's documented in various judgments that support his affidavit, and that's what I'm going to extract from that and share to request
So
information.
at this moment, there's no specific, that's going to be a follow-up information given to the committee and yourself.
Okay, in writing, yes. And I think on the issue of whether we've tried and mechanisms which we've tried to locate Mr. van Loggerenberg, yes, there is proof and there's evidence, and we will call some of the witnesses who were the investigators to before this committee when we present our evidence. Thank you.
Thank you, Advocate Mkhwebane. Honorable Gondwe.
I have, believe it or not, only 4 questions this time.
Aka utlwa hore?
I only have 4 questions this time, ne? Okay.
Thank you.
Advocate Mkhwebane, my question is around my question, well, 3 of my questions are around the meeting that you had with the Office of the Inspector General of Intelligence. And I want to find out whether the Office of the Inspector General of Intelligence was aware of the fact that you were recording the meeting at the time. That's my first question. And then you attached a copy of the transcript of the meeting with the Office of the Inspector General of Intelligence to the court papers pertaining to, I think it's the 2020 court action. Was the Office of the Inspector General of Intelligence aware that you had attached the transcript to those court papers? And then the PIA Act and the Intelligence Services Act make it unlawful for anyone to have in their possession classified documents. So my question is, and it touches on what Honorable Heron raised, was that if you were in possession and I think you've well, through your counsel, you've indicated that you were in possession of the classified report of the Office of the Inspector General of Intelligence. Did you take steps to inform the relevant authorities that you were in possession of this report, which was classified in its nature because it had not been declassified by the DG or by the Minister of State Security at the time? Then my last question is that you indicate in the 2019 report on the unit that you have it on good authority that there was a covert unit in SARS utilizing covert and intrusive methods. I just want an explanation on the authority that you based this finding on, because you said you have it on good authority. Is it based on what? I'm not entirely sure. So, and I wanted clarity on whether you were making this assertion on the basis of the classified report of the Office of the Inspector General on Intelligence.
That's good, thank you. Honorable Gondwe. Advocate Mkhwebane.
Thank you, Chairperson. Still on the advice of my legal team, I will respond in writing.
Thank you, Advocate Mkhwebane. Honorable Ompile Mautwe from the virtual.
Thank you very much, Chair. Chair, mine is not to Advocate Mkhwebane or Advocate Dalimpofu. It's just to bring to the attention of this committee that Honorable Maihem is actually the husband of Mrs. Mazoni, who is the complainant. And we've been seeing throughout the day how he has been harassing Advocate Dalimpofu.
Honorable Mautwe.
On the bias.
Honorable Mautwe. Honorable Mautwe.
My appeal is.
Honorable Mautwe, I want you to stop. You're out of order. I want you to refrain from that.
You have not heard my question, Chair. I was just giving the background.
I actually want you to withdraw what you've just said.
No, I won't withdraw anything. What am I withdrawing?
I'm going to repeat. Honorable Mautwe, I want you to withdraw what you've just said.
Withdraw what?
Honorable Mautwe, the 3rd time. I want you to withdraw.
What am I withdrawing, Chairperson? I'm asking you a question. What must I withdraw?
IT, please remove Honorable Maute from the
What
platform.
must I withdraw, Janji? What is it that I must
IT,
withdraw?
please remove
It's a
Honorable
fact that we had with the
Maute
husband of
from the
Mazoni.
platform.
Mazoni is a complainant. That's why we're sitting here. And he has
Sergeant
been
at Arms and
harassed
IT, please
by the
remove
It's a
Honorable
fact.
Maute from the platform.
This is not your meeting, Chairperson. We're all part of this meeting. I'm a member of this
Where-
committee.
where's the
and I
IT?
cannot be treated like I'm a stepchild in this meeting.
Can you remove Honorable Maute from the platform? Who's responsible for that? Thank you. Honorable Maneli.
No, thank you, Chair. I think initially when I raised the question, I thought there'll be an opportunity to get back because I had indicated that the questions I wanted to ask relate to the recording. Now that they are noted, I thought it would be important to just place them now and that they can be noted and responded to. I think the other question has already been asked, Chair, but I want to ask it differently in that, just to be sure also that I'm referring to the same report that it's referred to, that the Public Protector would have issued. That in the source documents used to get to the findings or the investigation itself, there is no mention of that report that has been received. Instead, I did see a letter from the Public Protector to that office of the intelligence, the Inspector General of Intelligence, as well as response as documents cited, not the actual report. I just want to check there, Chair, whether this would have been on the basis of the understanding that that report would have been a classified report. And if that would be the case, why use it then in the body of the report itself that she issued? So that's one. The second thing is just an understanding. In the recording, as I listened, there was a point made about conclusiveness of the report. I think words used were that to connect the dots, you'll then still need to engage people in SARS. Now, I just wanted to check if that would have happened, so that we know how the conclusions later would have been arrived at, right? So I think that's the point there, and maybe again, as I said, in mentioning the report, whether then this report would have been legalized later, because I think Honorable Heron would have raised this point. If not disclosed, that the report would have not been sourced properly. But of course, you'd have had sight of it because you received it in one way or the other. But at least do that, because this goes back to what we dealt with when Mr. Ibrahim talked to standards and so on. So it's a linked question in that score. Thanks, Chair.
Thank you, Honorable Maneli. Advocate Mkhwebane.
Chairperson, I will also, with the advice of my legal team, respond in writing.
Thank you, Advocate Mkhwebane. That was the last interaction on the questions. As you have indicated that, which we accept, that you will do all of this in writing. I just going to indicate that we are going to expect that we receive those in 7 days' time. And that's a timeline that I will be imposing and I take into account the work that you are going to be busy with outside of this process. So thank you very much. Honorable members and colleagues, I had indicated, Honorable Sukas, you want to say something before I proceed? From? Okay.
Chair, my concern is just that I think, and Chair must help me here, we are giving Honorable Advocate Mkhwebane the opportunity, according to the directives, to give that response. The witnesses that are going to appear before us are they having the same latitude? Because are we then fair? That is my question. Is it a fair process to anybody else who comes before the committee?
Okay. Those are the directives that we agreed to. Let's not go back there now.
People must learn to read.
Please, Honorable Malema, please refrain.
It's a question of fairness. It's
And
not
I'm-
a question of literacy.
No, don't respond to that, Honorable Sukas, please. Thank you.
But the directives are written. The directives are written. Read. You should have questioned them at that time.
Honorable Van Minen.
Thank you, Chair. Chair, in terms of Section 5.9 of the directives, it in fact states that the chairperson shall determine a reasonable time frame, and then goes on to talk about ensuring that the committee is able to properly fulfill its mandate and carry out its oversight function. And I think in line with that and in line with what the Honourable Sukas has said, we really must ensure that we are not allowing any particular individuals more latitude than other individuals, because the directives bind the entire committee, and we have to ensure there's equality of treatment of all parties concerned. Thank you.
Thank you, Honorable Van Minen. The chairperson has applied his mind and has given a reasonable time of 7 days. Thank you. Matter closed. Can I therefore proceed now to what I wanted to say? So we would have indicated earlier on that we had an intention to have Mr. Pillay having evidence led, but we're not able to do that. Because in any case, if we would have started with Mr. Pillay, we would not have been able to do the interactions with him on Monday and Tuesday. Because Monday and Tuesday is almost sacrosanct, we can't change it. We have a witness that has been subpoenaed, and we're not going to change that date for Monday and Tuesday. And therefore, there's going to be an amended program in that regard. And perhaps I can recognize Advocate Bauer, just if there's anything you want to say in relation to Monday and Tuesday. Because we as I indicated in the morning, from Tuesday, we'll take a pause of 5 days. And when we come back from that Wednesday, it is going to be a hectic process going forward. Advocate Bauer? If you have any comment you want to.
No, Chairperson.
Thank you very much. If there's none, therefore, colleagues.
Chair, I apologize. Were you about to adjourn? Were you about to adjourn the meeting?
Yes.
Chairperson, could I request that the committee not adjourn, but that we just stay and talk as committee members about some of the processes and procedures that have been...
I have already indicated in your absence when I started that there's a meeting we have next week, just as a committee between Wednesday and Thursday, and that is going to be confirmed. And the purpose of that is to iron out any committee issues that we have.
Chair, I accept that, absolutely. However, my concern is that we have at least 2 days of hearings before those processes are ironed out. So I'm trying to say that we should try and iron out any issues we have now before we go into another 2 days of hearings.
Okay, I don't know what those issues would be, but let's just pause. Honorable Malema?
Chair, earlier on, you see, we're not going to operate like this where people just get provoked time and again and then want to change the program of this committee. You indicated that we'll have Monday and Tuesday with the Public Protector virtually, and then we'll have Wednesday to ourselves. So there is nothing urgent here, Chair. People must not be provoked here by other things, and then what we adopted the directives, we're working within the directives, and we're going to proceed as such. Husbands must not come here and get irritated by our proceedings.
Thank you, Honorable Malema. Please, I want you to refrain from that language. Honorable members, unless there's an insistence, I do want to request that as I indicated, that we have set aside a day for a committee meeting. And we'll deal with quite a number of issues, including whatever concerns that members would have. Thank you for that and for your attention and patience. The meeting is adjourned. Thank you.
Long live the chair.
Recording stopped.
I do.
Tonight, I think that he would have been perfectly entitled to say, I can't answer now, or I'd like to take some. But you see, he's not accused. She, on the other hand,